Yes, sir. Nick Strakoff,
Here.
Carol Gutschel,
Here.
George Rodelius,
Here.
Lou DiGiovanni,
Here.
and Kathy Christie.
Here.
Attorney Tom Collins,
Here.
planner Frank Banish,
Present.
engineer Paul Ferrero.
Here. And if you could give us the open public meeting
Yes,
statement.
Adequate notice of this meeting of the Bedminster Township Land Use Board was filed with the Township Clerk, sent to the Bernardsville News in Bernardsville, Courier News in Somerville, to all subscribers, and also posted here at the Township Municipal Building at 1 Miller Lane, Bedminster, as of January 6th, 2015.
Okay, thank you. If you would join me in the Pledge of Allegiance, please. I pledge allegiance
To the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, I think we're going to jump all the way down to, oh, thank you. We have a camera now, so we need to make the announcement that, so everybody knows, the meeting is being videotaped and audio taped.
Mr. Chairman, before you skip down too far, what I'd like to do is stop at determination of completeness. I sent the board a letter late today on the Lamington Farm Club cottage expansion amended site plan application. That letter is dated October 8th. I felt that we could get to that completeness determination tonight. It's an addition to one of the cottages on the golf course with a footprint of about just under 800 square feet. The documentation has been submitted. They've requested a number of waivers based on the scope of the application and the fact that much of it has been previously submitted. It's my recommendation that the application be deemed complete, subject to those waivers.
Okay, thank you, Mr. Ferraro. Do I hear a motion?
So move to accept as it's complete.
Second?
Second.
All in favor?
No, we do
Do a roll call vote down? Okay, I'm sorry. Mr. Strakoff?
Aye.
Mr. Gutschel?
Yes.
Sorry, Mrs. Gutschel? I might call you mayor, too. Mr. Delius?
Aye.
Mr. DiGiovanni?
Aye.
Ms. Christie?
Aye.
Thank you.
Okay, thank you.
And Mr. Chairman, they apparently gave a public notice for tonight, unknown to, I think, anybody in the room except their attorney, and they've requested that the notice be carried to the date for the hearing. I think at the last meeting we discussed that would be on the November 5th meeting along with the advanced property use variance application. So, Tom, unless you have any issues, I think.
No, and they did submit a written request, and I think that's fine. We would carry, if the board is ready to, you could make a motion to carry the Lamington Farm Holdings LLC site plan application to November 5 at 2015 at 7 p.m. No additional notice is required.
Okay, great.
So move.
Great.
Roll call vote. Mr. Strakoff?
Aye.
Ms. Gutschel?
Aye.
Mr. DiGiovanni?
Aye.
Ms. Christie?
Aye.
Acting Chairman Rodelius?
Aye.
Thank you.
So, Paul, I think the next one would be Lamington Family Holdings.
Yes, Mr. Chairman, that's the cemetery application, and again, they're not prepared to move forward. They've advised that they will do additional notice when they're ready to come back in. So that's basically off for tonight.
Okay.
George, you skipped over public comment number.
Are there any, thanks, Nick. Are there any comments from members of the public on items that are not on the agenda tonight? Okay, let's jump right into KDC Solar. I think the last time we were here was April. Welcome back.
Good evening, Gary Hall for KDC Solar. Yes, it was April 30, actually. Almost May, but April 30. Yes, we're back. Good evening, Mr. Rodelius, members of the Land Use Board. We have our planner tonight to testify, if I could call him up. Great.
Yes,
I guess, Tom, you swear him in?
Yes, sir. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, I do.
And please state your name and address for the record.
Sir Michael Tobia, Tobia, the applicant's planning consultant, address 546 Van Buren Road, Morristown.
Okay, Mr. Tobia, you're a licensed professional planner of the state of New Jersey.
Yes, I am.
Can you briefly describe to the board your qualifications, experience, et cetera, as a professional planner?
Sure. So I'm a career-long professional planner. I hold a bachelor's degree in planning from the New Jersey Institute of Technology, a master's degree in planning from Rutgers University. I finished my grad work in 1981. Been practicing exclusively in the field ever since. Over the years, I've made, by my estimates, appearances before approximately 200 agencies of this nature, planning boards, zoning boards, town councils, as well as appearances in Superior Court, as well as a number of municipal courts.
And in those proceedings, you've been accepted as an expert witness?
Every time.
Okay. I would offer Mr. Tobia as an expert professional planner.
Board will accept Mr. Tobia's qualifications as a professional planner. Please go ahead.
Thank you.
Okay, Mr. Tobia, why don't you, rather than me interrupt, just tell the board what you've done in studying this project and what your opinions are as a planner.
Okay. So, as the chairman indicated, it's been, has it been 6 months? Is that right? 6 months since our last hearing. We thought what we would do is dust this off a little bit, briefly describe the site plan as you last saw it, by speaking to A15 to the board's right. And Mr. Collins, this is A15 dated October 2nd, 2014, so it's a year-old site plan. There have been no changes to the plan in the last several months, but we wanted to go through it with you so we all remember what we're talking about. And then I'm going to go through the planning proofs required of a use variance, and Mr. Chairman, I intend to do this all in about a half an hour. Okay, so we'll try and move it along.
And before you get there, just so we're clear, early on, you came to some of the meetings here, is that correct?
Okay, so I'm sorry, yes. So I've attended, I think, the first 3 meetings, Gary, and reviewed transcripts for all the others except for transcripts related to stormwater, because I had a chance to talk to Rob about stormwater. So I've reviewed probably about 8 transcripts, I'd say.
And you've seen the exhibits and the comment memos, et cetera?
Okay, yeah, we should back up. I've reviewed all the comment letters, all the exhibits, the master plan, the zoning ordinance. I've been out to the site, on the site, a half dozen times probably by now, as well as around the neighborhood perhaps 20 times.
So your review of the proposal is based on the record that's already before the board here?
That's correct.
Okay, thanks.
Okay.
And then, once you proceed, then.
Okay, so as you all know, this is a proposal for a solar facility on a piece called the Kirby Farm. The applicant is KDC SA55 LLC. The house that's now on the property has an address of 305 Country Club Road. Although there are 3 lots involved, virtually all of the activity proposed by the applicant is on Lot 10. The proposal is to build a 10,000 megawatt solar facility to serve the corporate offices of the Sanofi facility located to the east of us in Bridgewater. If you look at A15, you'll see basically the subject property, meaning Lot 10, which is the rather large parcel that goes down the center of this exhibit, a Lot 4, which is controlled by the applicant but will not be built upon, and then an isolated lot known as Lot 1, a skinny little thing in the northeast corner of this exhibit that will eventually be merged with the main lot if we get an approval from you all for the application. The installation is intended to collect solar and convert it to electricity to serve roughly 75% of the Sanofi needs across the highway. If you look closely, you'll see there's a blue dashed line that shows where a jack and bore operation will go under Lot 4 and then under 287, a run of approximately 2,025 feet to the Sanofi campus. It'll terminate about 100 feet from one of the buildings over there. Okay. This project is basically divided into two sections, a westerly portion and an easterly portion. The total panels, as you heard explained by our engineers, now numbers about 33,000 solar panels. You may recall from over a year ago, there was an earlier plan that showed up to 40,400 panels. So there was one major plan revision from when we got started 2 years ago until roughly a year ago. The new plan is what you see now. We're at 33,000 solar panels. And roughly that breaks down to a third to the east and 2/3 of the panels to the west. The whole enclosure in fences around each of the two collections, the two clusters, is about 38 acres of the 132 acres on the overall property. So 38 acres, as we've said in the past, is in the fence, meaning it's the fenced enclosure. Everything else is used for setbacks and buffers. Okay. Let's talk about the clusters for a second. And one of the big things I have to share with you tonight is a discussion of setbacks and buffers, because I think it really speaks to how this thing will be hidden from public view from both our neighbors as well as passersby on Country Club Road and Meadow Road. Speaking of which, let's remind everybody Country Club Road is located to the right or east of the exhibit. And then we are on a corner lot, and Meadow Road runs to the south of the exhibit, angles south toward Bridgewater in the lower portion of Exhibit A15. The easterly cluster on the property, as I said, yields about 1/3 of the total panels. The front yard setback from Country Club Road at the elbow, I'll call it, is about 237 feet. So indicated with my pointer. Yes, it's right about there. This tapers up to 690 feet in the northeast corner of the site. It provides a steady 200-foot setback across the entire northerly property line, contiguous to Preston Terrace and Somerset Terrace to the north. As far as Meadow Road goes, it's about 780 feet from the nearest panel, and all these setbacks I'm going to share with you are from the nearest panel, 780 feet down to the elbow in Meadow Road. Okay. The westerly cluster provides a similarly large setback of approximately 700 feet from Meadow to the nearest array. It provides a 211-foot setback from the nearest array to the southerly property line, not to the road, but to the property line. It provides 200 feet of setback again off the northerly property line, and it provides 240 feet off the westerly property line, abutting, I recall, is Lot 10. No, I'm sorry, Lot 9 to the west. Okay, so this was laid out, just so you know, to treat the panels as if they were a permitted use in the zone, which would require a minimum setback of 200 feet. So if you're a house and, you know, some of the other permitted uses in the zone, although they're much taller than panels, we took that 200-foot setback as gospel, used it all around the site, and in many areas expanded it to a much greater setback. There are 7 inverters proposed on the site. On these little rectangles, you see these pads that convert the DC power to AC power. They're basically cabinets that look like small refrigerators. Okay, a 7-foot high chain link fence now encircles both clusters. In select areas, that 7-foot fence, as you may recall, will have a dark green fabric mesh on it to hide the panels that will be along the entire northerly property line. Will have that fabric, as well as the southeast and south portion of the easterly array. Everything else will be fenced with a 7-foot-high enclosure pursuant to the, what I think is the National Electrical Code. So this is an enclosed facility with gates that enter the array and otherwise is completely encircled by cyclone fence. The house, the garage, and the existing driveway remain. A second driveway will be added up to the northerly end of Country Club Road, where it will connect to a small 12 by 20 or 11 by 24 enclosure that will have other utility equipment as well as the jack and bore operation for the property. That little area shown thus in the northeast corner of the site will be encircled by fence and the fabric as well. Okay, it's about 200 feet back off the street. No lighting's proposed, no security lighting's proposed, no cabinet lighting is proposed, so this is an unlighted facility. Landscaping, let's talk about it for a second. There's an aggressive landscaping plan along the easterly cluster of the proposed installation. Is a landscaping plan that proposes 17 shade trees, 42 evergreens, and 3 shrubs. That is the area more or less parallel with Country Club Road. Along the northerly edge of this same cluster is a berm. Talked a lot about this through engineering testimony. It's about 1,150 feet in length. It's about 2 feet high at its lowest point, 7 feet high at its highest point, and that area will be planted, in addition to the fencing, with 36 shade trees, 30 evergreens, and 80 shrubs. There was dialogue with a property owner to the north several meetings ago with Mr. Hoynes about landscaping needed off to the northwest side of the site. This is Mr. Hoynes' property, upper left of A15, and additional landscaping was provided in that area. And you can see, if you look closely, a long black line up here that depicts a total of 224 evergreens. Okay, it's important to note the tree line along the northerly property line that now exists, the tree stand along the westerly property line that now exists, all the plant material along the property line on Meadow Road, and the valuable hedgerow and scrub that you see in the northeast corner of this site will remain undisturbed. I think I mentioned the berm across the top. I mentioned the jack and bore that goes under the highway. And let's talk quickly about how the plan has changed. In addition to panels being reduced in number from 40,000 roughly to 33,000, panel height was reduced also. You might recall there was an 8-foot-high panel proposed with the initial app. Now we're down to a panel that at its maximum height is 5 feet. Panels have been pushed closer together to create better economies within the field, so the spacing between panels is now about 5 feet on average from 9 feet previously. Importantly, the most significant revision was the removal of all panels, grading, berming, and plant material in the southeast corner of the site near the intersection of Country Club and Meadow Road. So the farmed field you see out here now, which is a field that's occasionally hayed and provides really valuable topographic change moving from the roads up to the center of the site, stays exactly the way it is now. Previously, that was more or less covered with panels. The switchgear area to the northeast corner of the site has been moved 150 feet further from our neighbors up on Preston. This setback now is approximately 350 feet. It was only 200 feet with the earlier plan. We mentioned the fencing. It's now chain link covered with a kind of a camouflage mesh, a dark green mesh that will prevent you from seeing through the fence. Lot coverage, we'll talk about later. It's been reduced to 15.9% from 17.1%. The overall footprint of the project, because we're now omitting that area, folks, in the southeast corner of the site, is now down to a disturbance of 38.6 acres from 53.2 acres. And one other important change, and a final one, is this project requires a service road for folks to get in and access the site, mow lawns, maintain facilities, things like that. We had a service road previously proposed along the northerly property line. It was roughly 25 to 50 feet from the northerly property line. I think there was input that it was too close to the homes up there. It's been moved all the way to the center, more or less the exact center of the site. Still runs east-west from the existing home out to the middle part of the western cluster. It is now 720 to 880 feet from the property line. So it's moved away by 700 feet minimum, roughly. Okay. There is now no service road proposed up top. Okay, and there's still access points that would run north-south through the clusters. So that's what's happened. That's where we are with the plan now. It hasn't changed in a year. There was a topographical and plant analysis that was done, that was discussed by Mr. Kennedy a year ago, that concluded, and I agree with this, I've been over it carefully, that from Country Club Road, from Meadow Road, and importantly from our residential neighbors to the north, the use of existing plant material, proposed plant material, berming, and fencing will all virtually completely shield this thing from public view. Most of that's achieved just by these rather large setbacks that we've proposed, which run from 200 to, I think I said, 780 feet off of Meadow, and also because we're dealing with objects that are 5 feet high. Let's talk zoning for a couple minutes. It's okay, Gary?
Sure.
This is an R10 zone. It's a rural residential zone, minimum lot size of 10 acres. The zone permits a variety of land uses. One is farming and various agricultural land uses. One is single-family homes. Another is houses of worship. Permits a variety of schools. It permits airports, boarding schools, open-air clubs, golf courses, and facilities to support ag. Okay, so it permits a fairly wide variety of uses. It does not permit solar. So consequently, we're before this agency to ask for what you all know is a use variance. In addition to that, there is some discussion, and this was in Mr. Ferrero's report from many moons ago, about the possible need for a lot coverage variance. This is mostly a legal and interpretive question. I wanted to tell you, though, that if Mr. Ferrero's interpretation of the ordinance is recognized, you have a requirement for 5% coverage maximum in the zone. You have an existing condition of 0.13% coverage with the existing house and driveway, meaning a little bit more over 1/10 of 1% of coverage on the site. And if the panels are included in the calculation, now you have a 15.9% coverage condition. So 5% proposed, 15.9% if you counted all the panels. We'll get more into that in a minute. This is a use variance case, first and foremost. Solar is not permitted in the zone. Your solar ordinance and ordinances in general recognize that an accessory use like this is normally required to be on the property that it is intended to serve. When you build a garage, you expect it to be on the same lot as the house. Build a swimming pool, you expect it to be on the same lot as the house. We have an anomaly here because we cannot locate solar on the Sanofi piece to the east in Bridgewater. We're looking for the next best thing. It is a use variance. We're going to put proofs on right now. Normally, when you ask for this type of variance, as you know, and Mr. Collins has advised you over the years, you normally have tests established by the Supreme Court in what's called the Medici decision that say you have to provide testimony that says the site is particularly suited for the use and that it consequently promotes the general welfare. That language usually means the proposed use and the site are reasonably distinguished so that the use of the site to accommodate the non-permitted use is deemed acceptable by the board. It's called the special reasons or the positive criteria. Several years after the Medici case came a case, 5 years to be exact, called Sika. And Sika zoomed in on what happens when you have inherently beneficial land uses. What Sika said back in 1992 is the standard of Medici does not apply to things like churches and hospitals. We want to relax our zoning review of uses that help the public to a great degree, and they modified the standards of Medici, and they simply said, if you're inherently beneficial, you automatically meet the so-called positive criteria. You don't have to show the site's particularly suited. You're granted as a matter of law that you've satisfied that portion of the test because you serve the public good. Sika also said that it's only commercial uses that are subject to this particular suitability test. It also said that inherently beneficial land uses are too important to be prevented from locating on appropriate sites if you can impose reasonable conditions and qualifications. Sika went on to say, don't get too strict in your review of the detriments of a use such as a hospital or a school, because if you do, you can deny anything. And the law clearly favors these land uses, and so it suggests a relaxed review of inherently beneficial land uses. I tell you all that because in 2009, solar, through an amendment to the municipal land use law, was deemed by definition an inherently beneficial land use. It was merged with uses such as hospitals, schools, child care centers, group homes, wind, as inherently beneficial. The statute in 2009 also said solar is defined as a use, whether it's a principal use or an accessory use. Okay, which means whether it's on the property to be served, maybe on another property, whether it's the only use of a parcel, or just a use such as what we're proposing here, which is ancillary to Sanofi. The law is clear that we are an inherently beneficial use. Consequently, we meet the special reasons test, which is one of a two-pronged test for this use. If we didn't, and if we were not an inherently beneficial land use, the other test I just told you about would be easily met by this applicant. That test just says, are you particularly suited? Here you've heard through, I think, 6 witnesses before me that says Sanofi has massive energy needs. Sanofi's ownership, the people who own those buildings, and it's not Sanofi, will not allow solar on that property for a variety of reasons. A new site's been selected immediately adjacent to Sanofi, the subject property, which is huge and can do 2 things with its rather enormous land area. 1, provide enough space for the panels that we need to power Sanofi, and 2, provide even more space for buffers and setbacks. The size of the property and its proximity to Sanofi lead me to conclude this easily would have met the particular suitability test if it was required. Perhaps more importantly, Solar, as you heard from our first witness, I think Tom Lynch from KDC, provides enormous societal benefits in terms of a world now struggling with climate change, energy shortages, energy dependence, air pollution. Solar is a use that's an alternative energy source. It's renewable, sustainable, mostly pollution-free, and a lower-cost energy source for people like Sanofi or people like us who want to put panels on our homes. So there are a variety of public benefits that come with solar, in my opinion, that are indisputable and exceedingly important if we want to move to a greener society and also to a more economically stable society. People, companies, I should say, look at electrical, they look at property taxes, they look at traffic congestions as reasons to move out of an area. One way you stabilize a big employment base like Sanofi, which has 3,000 workers right now at that facility, is lower the cost of electrical power. That's another benefit of what's being proposed by this applicant. For all those reasons, I think it's easy to conclude we meet the positive criteria for this case. It's also important to point out your master plan, which we're going to talk a lot about in the next few minutes, has goals that specifically say encourage the use of renewable energy. At a minimum, you could look at pages 3 and 30 and 35 of your master plan. That says just that, okay? Encourage the use of renewable energy. The municipal land use law also, in goal N at the very beginning of that document, says promote utilization of renewable energy sources. So this application satisfies goals of your local master plan as well as the all-important municipal land use law. Now, as nice as all those things I just said are, if you can't satisfy the second prong of the test, you should not be able to get an approval for an inherently beneficial land use. Second prong of the test, therefore, is called the negative criteria. And it says no variance, including inherently beneficial variance requests, can be granted without a showing that the variance will not be a substantial detriment to the public good, nor substantial impairment to the intent and purpose of the zone plan and zoning ordinance. I wish, unlike our court reporter, I remembered to bring a bottle of water with me also. So we have a couple things we have to talk about. You have any vodka? The breakdown here is this a really bad thing for the neighborhood? Does it really impair your zoning ordinance, which is a nice document with a great vision for Bedminster? I want to go through first the substantial detriment test. Is it bad for the neighborhood? Is it a substantial detriment to the public good? Substantial means considerable, it means real and tangible, it means essential, and it says in Webster's, it doesn't mean imaginary, okay? It's got to be substantial, and the courts have always emphasized the word substantial in this analysis. We show you here a parcel that is 13 acres, or 13 times the 10-acre minimum lot size in the zone. Okay? It's massive. Not only does it greatly exceed your minimum lot size, it also allows huge buffers, setbacks, saving of trees, saving of hedgerows, and the addition of plant materials and fences with ease, even though we do need a lot of land to do the panels, 38 acres more or less to do the panels. So we have a lot of land. We meet setbacks if we were building a house or a church or a school on this property. You'd be subject to a 200-foot setback. And for 5-foot high panels, we easily meet that 200-foot setback all around the property. We've added, as I've told you, hundreds of plants, both evergreen and deciduous. We added a berm along the northerly property line, an evergreen screen along the northerly property line where our residential neighbors are. Perhaps most importantly, this entire swath of land to the west of Country Club Road has been or will be retained in its natural state to block this facility from public view. Topographic conditions along the road have been examined. Country Club roughly ranges from 120 feet elevation to 130, maybe 135, whereas the center of the site goes up roughly 20 to 30 feet above that. Mr. Kennedy explains that as you move up that slope, you reach the top and you have a crown. It's that crown or bowl that will block much of the view from the all-important Country Club Road from passersby. This site right now is not exactly what I would call an open scenic vista. If you go out to Rattlesnake Bridge Road, is it? Rattlesnake Bridge Road to the west side of town, and you look west, you'll see scenic vistas that extend perhaps well over 1,000 feet. Here you have a vista, which is valuable, but it only extends 200 or 300 feet mostly across the front of this area. It's all being preserved. We think that helps conclude that your scenic vistas and your nice driving condition along Country Club Road, which is beautiful, and along Meadow Road will be retained exactly as you see them now. The use of the green mesh and fencing 7 feet high, which is higher than the 5-foot berm, will also guarantee encircling the panel material with something that cannot be seen through and will provide further shielding of the facility. I wanted to talk for a moment. I know it was Chairman Boxer who raised questions about agricultural soil and farmland preservation. My conclusion is, and let me back up a little bit, a little foundation for you. It was established by Mr. Kennedy and his aerial photography analysis, as well as my hiking through the entire rear of this property, that the back half of this site, meaning Lot 10, obviously hasn't been farmed for 25 years or more. It's covered in cedars, some hardwoods, a tremendous amount of undergrowth. The evergreen plant material you see out there in a lot of spots is 20 feet high. It takes a long time for that stuff to get 20 feet high. Whether this is prime ag land or not, it hasn't been used for farming since Mr. Kennedy said since the late 80s. I agree with that. The front portion of the site is lightly farmed at best. Right now, the only actively farmed area is, in fact, this area at the corner of Country Club and Meadow. It was hayed recently. The rest of where the solar field is now, the easterly cluster, is in kind of a meadow condition. We've been told by the person who maintains this that right now the yield for hay, the demand for hay, which is what's being harvested here, is relatively modest. These fields get rotated. First, it's the third field down below, and then it might wander up to behind the house, and then it might wander up to the northwest, depending on the season. The yield right now, agriculturally speaking, is about 12 acres gets cultivated a season. That's exactly how it would remain if this application is approved, and it would be this all-important front corner, which not only provides yield from an agricultural standpoint, but it also provides the visual of farming at the most visible part on the site. Beyond that, in terms of agricultural activity and farmland preservation, it's important to just remind you, and I don't do grading plans, but the engineering witnesses have explained there is no soil export taking place as a result of this project. Okay, none of the ag soil is getting scraped up and taken away. Only a minimal amount of the soil on the site is even being contoured right now. Some activity will take place along the berm to the north, and some grading will take place to do detention basins. The vast majority of the site is staying just the way it is. All the panels are being ballasted now. Nothing under the panels is being graded or leveled to put those panels on it. And if you've been to solar fields elsewhere, unlike buildings, we don't have to flatten the site to build the building. The panels will gently meander down slopes, of which there are a few on this site, without the need for any grading under, say, these panels to the west. For those reasons, I conclude that this is a big goal of your master plan. The farmland here, if this lease ends, say, 20 years from now, can immediately be put back to its current condition. Whether it's farmed or not, I cannot predict. The conclusion is we are not forever compromising this site as a eventual farm site, and in the meantime, we're at least using a portion of it to maintain the visual and agricultural yield of farmland. In one of the more creative approaches on this job, the applicant will be mowing lawn and hay and wildflowers within the fenced enclosure with sheep. There will be no lawn mowers used, no tractors, and only a minimal amount of weed whackers. This has been tested on 2 other facilities they have with tremendous success. As far as our neighbors go, that means you're getting basically a noise-free, pollution-free solution to how we maintain that ground area under the panels. The applicant, if they haven't already, and we're unclear on this, will be submitting to you all a decommissioning plan that explains what happens if the facility does leave us in 20 years, how the material is removed, how the berms will be graded back to their existing state, to guarantee you that this isn't left out here as a mess when everything is finished. Your master plan looks at your R10 zone, and it calculates that the zone covers an amazing 13,000 acres of land. The disturbed area on this site for solar is 38 acres. It works out to 1/3 of 1% of your entire zone. Had, hypothetically, we put 38 acres into the middle of Pluckerman, let's say, in the business district, it would devastate the business district. 38 acres is a lot of land in Pluckerman. Here, it's 1/3 of 1% of your entire zone district, surrounded by a 200 to 700 foot plus buffer. I view its impact on your zone, the R10 zone, as microscopic. Okay. Beyond that, this is a really unusual land use in terms of the development impacts we normally ponder when we review cases. It has essentially no traffic. It has no lighting. It has none of the usual emissions and pollutions and things of that nature. You heard from a very skilled acoustical engineer a few months back, Norm Dottie, who said you will not hear anything at the property line. And he boasted a little bit. He said, I never get to say that. But this is basically a silent land use at the property line. I've witnessed it myself. Most of the noise that comes from this is around these inverters. By the time you're 20 feet or 30 feet away from these cabinets, they're mostly silent in the context of the ambient noise pattern. So we have no traffic to speak of. We have no acoustical impact to speak of. The visual impact here, I'm confident, because these panels are so small in height and our setbacks are so great, will not be visible in any way that can constitute a substantial detriment to the neighborhood. Stormwater's been talked about at length. That's not my field of expertise. The conclusions there by Rob, our engineer, was that recharge, attenuation, water quality will all be met. And I think the final exchange with Mr. Ferraro was that there may be some things that have to be tweaked, but that the applicant's fully willing to do that as we move through getting this from zoning to construction. So maybe that was 35 minutes, but I kind of got through it as best I could.
I do have a couple more questions.
Yep.
So,
So you're going to slow me down, Gary?
I don't know if you're about to stop, but you said early on that the solar, this use is not permitted. Now, the town did adopt the solar ordinance last year. Can you respond to that? And it's been, I think I argued against it, but there was a ruling that applies to this project. Could you go through that and address consistency and how that fits into the mix?
And your planner, Mr. Banish, also wrote a nice report on this topic. First of all, it's important to note the solar contemplated in the town, which is a town-wide ambition. I think pretty much every zone permits some type of solar, whether it's rooftop or canopies like you have out in the parking lot here, or ground mounts like you see proposed by KDC. A couple things that we fall short on is an expectation in the ordinance that the solar should power a building on the same site. Okay, we don't do that. We need a variance, or we need you to understand that that's subsumed within the whole variance that we've talked about before. It says the principal building must be on the same lot. It says no new access drive should be permitted. You should use existing curb cuts. I told you we have that existing drive to the north of the site on Country Club Road. However, the ordinance also says some things that I was persuaded by and I think are pretty positive, and I wanted to share them with you just quickly. It establishes in its preamble a remark that says solar should be as inconspicuous and unobtrusive as is reasonably possible. And I believe this applicant has done that. Okay, the fencing, landscaping, berming, setbacks, and use of existing topo meet this rather balanced statement that says inconspicuous, unobtrusive, as reasonably possible. The ordinance also says panels can't go to more than 6 feet high. We're at 5. The ordinance also says that you can use buffers. It recommends a planting schedule, which we have far exceeded in terms of minimum number of plants that can be provided. It says existing features may be substituted for buffering material, including hedgerows, forested areas, and existing buildings. Now, this plan saves a nice hedgerow and tree line along Meadow Road. It saves all the plant material to the westerly property line. It saves a 200-foot swath of tree material, now existing probably 50, 60 feet high in the northwest section of the site. It saves an extremely valuable tree line between our neighbors on Somerset and Preston to the northeast of the site. It retains this scrub, hedgerow, scrub and cedar growth, which doesn't show well on this aerial, incidentally, but is extremely valuable in blocking the view from Country Club Road looking due west at our easterly panel. So it meets the spirit of your ordinance in that respect. It talks about providing a fence inside the perimeter landscaping, and we're doing that. So all our plant material goes outside our proposed fence. It says no solar facility may be located in a critical area. 2 engineers on our side have confirmed that. There's nothing about this that's going into wetlands, let's say. It suggests as mounting devices things like earth screws, auger driving, or similar systems. We originally on this job proposed pile driving of all the facilities, if you remember. We switched that to a ballast system, which is less invasive And these are just like 1,000-pound weights sitting on the solar arrays to stabilize these things without any ground penetration. We think that meets the broad intent of your ordinance. The ordinance says minimize soil disturbance for the reasons I've mentioned. We're really doing a heck of a job with not moving around a lot of soil, with zero export of soil from the facility. The ordinance says use shade-tolerant grasses to stabilize soils. I have to tell you, I've been to a couple KDC facilities. Their use of soil and grass and wildflower materials along the carpet under these panels is extraordinarily successful. I believe that's all shown on the plan, but you all should be clear, KDC has this down to a science, and if you're looking at stabilization, ground cover, they've done it. The ordinance does say also that no portion of a ground mount shall occupy prime ag soils. Here's an area where I want to repeat what I said. A lot of the soils are not being disturbed. The ones in front, which are the active ag soils, will remain in this use. We're going to use the same farmer. We're going to hay just the way we do now, and you're going to have that visual and that productivity up in front. Anything that's ag soil all around will remain as such. Everything at the rear of the property hasn't been farmed for a couple and a half decades anyway. When this job is pulled, if it's ever pulled from the site, the soils that are there now will be the soils that are there a couple decades from now. I also want to point out, in all fairness, for a balanced ordinance, if you built a home, if you built a golf course, if you built a church, if you built a school on this property, you'd be destroying or disturbing ag soils a lot more than what's going on with this application.
And on your review of the ordinance, are there any regulations that restrict or prohibit development on ag soils that you've seen?
Yeah, no, it's a good point. If you go through aside from solar, if you go through your entire ordinance, I don't think there's a provision in there that says you can't disturb ag to build a home or you can't disturb ag to build a church. It appears nowhere but in your solar ordinance, and we've done our best to comply with that. So you forgot to ask me about lot coverage.
Right, that was the other item on my list. You mentioned it early on and said you'd get back to it.
Right.
Why don't you say a little bit more?
I just want 2 minutes on this, and then I'm finished, Mr. Chairman. Your ordinance has a requirement that controls coverage of land with a term called lot coverage. When the solar legislation was enacted a few years ago, the state, through the municipal land use law and other statutes, said impervious coverage caused by solar panels, meaning the actual slanted panels used to collect sun, shall not be included in the calculation of impervious coverage. Your ordinance does not use the term impervious coverage. It uses the term lot coverage. Mr. Ferraro, therefore, has said, well, panels should be calculated within it. And that's why we gave you that number of 15.9%, which is triple what the permitted coverage is. However, if you look at the definition in the statute, impervious coverage is the term of trade that they use, and impervious coverage is a term used in your definition of lot coverage. So your def says lot coverage includes the term impervious coverage. The statute says any solar panel, as defined herein, shall be exempt from any calculation of impervious surface or impervious cover. The statute was so strict and so emphatic, it wasn't just the municipal land use law statute that was exempt, it was all these other land use statutes that planners get to use, such as Pinelands, CAFRA, Highlands, County Planning Act, and others. I think the two terms are synonymous. I think the focus that you should have, and the attorneys have to work all this out, the focus you should have is the coverage provided by everything but the panels, which equals 3.59% and is below your 5% threshold.
And the 15.9 number, what does that include?
All the panels as well as everything else.
Okay.
So just so you're all clear of this, the 3.59 means the driveways, both existing and new, the home, the garage, these trails, folks, that run through the property, the pads under the inverters, the pads under the switchgear, everything but the surface of the panel is how we got to that number of 3.59%.
And Mr. Tobia, assuming using the township interpretation, the 15.9%, do you have an opinion whether, if that applies literally, variance relief would be appropriate?
So I do. Some of this does veer off into engineering, and I know you covered that already. If you go out and look at a solar panel, all it is a slanted 3x5 piece of glass and aluminum. All the water does, folks, is slide down that and end up underneath the panel anyway. This is an inherently beneficial land use. I feel flexibility, Gary, on what I consider a rather minor bulk variance is acceptable, given that it's inherently beneficial as well. And I did want to wrap up.
And while you're on that, would that same opinion apply to the extent that there are technical deviations from the solar ordinance, and if it applies?
Yes, I think solar's swept through. The long and the short of your solar ordinance is you don't allow a facility of this size to be located any place. You do have zones that permit ground mounts. The zones are too small and too far away to work for this applicant. You have ground mounts permitted in R10, but the way it's constructed, there's absolutely no vision that it's supposed to go and use a major facility like Sanofi. So when zoning doesn't work, when it prohibits things, when it's so complicated you can't get a use that you want, you are entitled to make application for a use variance. That's why this board exists and the process exists. And the applicant's asking for a use variance. I close by saying KDC and I and Gary worked out some calculations on what 10 megawatts means. It's the equivalent of 1,233 single-family homes and their annual electrical usage for a year. That's more single-family homes than Mr. Banish shows in the master plan for your community right now. A little bit more, okay? But that's the magnitude of the benefit here, is that this is a lot of electricity, a lot of sustainable electricity for a corporate user that has significant regional benefits for not only Bridgewater and Bedminster, but the whole area.
Just one quick follow-up. You said we came up with a number. Wasn't that based on US EPA figures?
Yes.
We didn't pull it out of the air.
We didn't pull it out of the air. There's scientific conversions that, and anyone could look it up. I think it was called the EPA calculator, Josh. The EPA calculator. It converts solar savings into how many cars you could get off of the road, how many houses you could use, how many lawnmowers. It's a nice conversion. The one we used was just homes. And it's a lot of power. It's 3,000 employees, after all, who would benefit from this. And it's a lot of juice.
Okay, that's fine.
Okay.
Well, you got to stay here.
Okay, thank you very much, Mr. Tobia. Okay, we will have public comments. We'll have comments from the board and the objectors' attorneys. I think we should jump right into the objectors' attorneys at this point. And then we'll maybe take a 10-minute break in about a half hour or so.
Would you mind? I'm going to shake it and point it at Mr. Sasso.
That's okay. I got my eye test today and they're already failing, so.
Well, your arm looks a little better this time.
It does, it's getting smaller. The glass is half full.
I guess you didn't run into me again, right?
Speaking of pulling things out of the air, Mr. Tobia, when you say tonight to this board, Tobia, that the panels cannot be seen on this project, and that's what the engineers testified to, can you tell us what you're relying on to make that statement?
So there were, Mr. Sasso, cross-sections done by Mr. Kennedy, and we all worked on them, and testimony in July of 2014 by Mr. Kennedy that said cross-sections were examined. The conclusion was when we add plants to fence and berm through a variety of cross-sections, the panels would be shielded from public view.
From any vantage point whatsoever is what you're saying?
Yes, it's a good question. The analysis, I'm just going to draw a few lines on the
Sure.
exhibit here.
Please.
There was one cut from Somerset
Right.
down to the corner. I think you remember some of these.
Sure I do.
There were a couple cut east to west
Sure.
through the site. I believe there was one from Preston cut down to Meadow, and there was a really valuable one cut from, is it the Fort residence? The Fort residence shown just south of the intersection, Mr. Sasso, moving through the farm field.
All right, and you also base that on the intimate knowledge you have of the berms that are being constructed as part of this project, correct?
Yes.
Why don't you show us with that red pen you have, the berms on the left side of that project where my client's property is located?
So you were talking about lot 9, hold on a second, I'm sorry, and there are no berms. You're talking about this property line,
Sure.
Mr. Sasso?
Sure.
Yeah, so that's a good question. There are no berms over there because of the density of existing plant
And
material.
not even plantings, correct? And this, is that correct?
That's correct.
So we're talking about the scrub brush that was described by the engineers as being what would block someone's view from that vantage point, correct?
And in that area, hardwood plant material also, some taller trees in that area, we thought would do the job, yes.
I'm just wondering, sir, how from the time Mr. Kennedy testified that he couldn't say unequivocally that you wouldn't see the panels, that tonight you come to testify before the board and say that you couldn't see the panels from any vantage point, and yet you talk about some cross-sections at certain points around the property. Let me ask you, sir, are you testifying under oath today that if I walked the perimeter of this property post-construction, I would not be able to see a single solar unit?
No.
Okay. Now, let me ask you this. In connection with your review of the materials here today, you did say before that you are not an expert in terms of stormwater management. Did I get that right?
Correct.
Okay. How about with regard to solar energy?
So I am a planning expert. Solar is, if you're asking me if I'm an expert in solar, the answer is no.
Okay. How about your experience in solar? Have you ever testified on behalf of an application before with a solar or electrical generating plant of over 30,000 panels?
So, yes, and one, which was the recent one up in Peapack,
And how many years have you been in this business?
34.
Okay. And when you come before this board and you say, everything's okay, this is a project that should get passed and there'll be microscopic impact to the neighbors, I believe that's what you said. Can you tell us what information you have with regard to the reclamation of these solar materials at the, quote, end of the job?
So, no. We had a Mr. Reaver, the solar expert, who did explain that. So it's outside of my field. I could tell you quickly what he said, which was...
Well, no, I know what he says, and they heard it, and that's why I'm asking the question.
So then, If
Okay,
you're
so-
asking me, then I have nothing new to add on that topic.
Okay. Do you have anything to add, positive or negative, as to whether or not there's any type of possibility of a toxic event, a negative toxic event, a spill on this site in connection with this project, yes or no?
No.
All right. In terms of your testimony here this evening, tell us what you did review.
So I've been on the job for 2 years now.
Sure.
As I said, multiple site inspections. We reviewed the master plan, zoning ordinance, solar ordinance, all the site plans, and their various revisions. I think I told you I read all the transcripts, attended the hearings, and I want to emphasize, walked this site extensively to understand impacts.
Okay. So you didn't mention it, but I'll ask you, did you review the two reports that were issued by Mr. Banish?
Yes, I'm sorry, I forgot that, yes.
And did you review all of those reports? By that I mean comprehensively.
There were 3, not 2, and the answer is yes.
Okay. And in connection with his reports, they were issued by him as the Bedminster planner, correct?
Yes.
And based on your experience in this area, he's been the planner here for decades?
Pretty old guy.
Yeah?
Hey,
Is that a yes?
Yes.
this line of cross-examination must stop.
It's not.
I'm over it.
asking a woman for age. I have broken knuckles that would attest to that mistake, but in any event. Getting to the master plan, which we'll talk about in a little bit. On the master plan, you reviewed that too, right?
Correct.
All right. In fact, Mr. Banish's name is on the front page of the master plan on the bottom, correct?
Yes?
All right. When you talk about a D variance based on your experience, you told us that there were 2 prongs, correct?
Yes.
All right. That first prong dealt with the special reasons, if you will.
Yes.
All right. But we know in this case, at some point, the legislature changed the definitions in the MLUL. Is that correct?
Yes.
And that's in 55D-4 to include solar in the definition along with hospitals, for instance, schools.
Sure.
All right. I want to talk about generally about that special reason. If you have a special reason, for instance, a hospital, I think that's a good example, and it's cloaked with that definition of being a inherently beneficial use.
Right.
If that application for the hospital comes in with 2 hospitals already there, okay, and now a third one down the street in a residential neighborhood, let me ask you, in your opinion, do you ever get into the need issue? By that I mean, although it's not a permitted use, but it's inherently beneficial, but does the board look at, hey, do we need that?
So it's an interesting question. Generally, I don't. Okay? I do think a board could look at this and say, hey, we have 2 hospitals, do we need a third? I think that's your premise. But generally, I think, the law here has been simplified to ease the burden on a use like a hospital. And right now, when you read that statute, Mr. Sasso, statute doesn't say, hey, the third inherently beneficial use in has a higher burden of proof. So I hope I've answered your question. Maybe you can follow up if I didn't.
Sure, absolutely. But there's been case law that you've been aware of during your tenure as a planner that has kind of said that, right? Even post-Medici.
So you're going to have to be more specific.
Sure. In other words, that besides the fact that it's inherently beneficial, the board can look at other characteristics, like need, for instance, 3 hospitals in a row.
I totally get it, yes.
Okay. Now, when we look at a D variance, even if a certain application is solar energy, for instance, and we know that 55D4 says that that's an inherently beneficial use on its face, That's not the end of the evaluation for the board. That's the beginning, correct?
Correct.
I just at this time, and I'll pass one to council too. This is just 4055B70D, which is a section that we're talking about. I have enough copies for everybody.
Thank you. We'll share.
Thank you.
Thank you.
I don't know what is on these.
I guess myself.
Thank you.
All right, you with me?
Yes.
Okay. It's a statute you're very familiar with,
Yes.
right?
Yes.
The first section talks about the power that the board has to grant a D variance. Would you agree?
Yes.
But that variance can only be granted if the second part of the statute is complied with. Is that right?
Yes.
And what does that say?
So, bottom paragraph, is this marked by the way?
No, it's a
No.
It's a
statute.
statute, so I don't
Okay.
think.
It's a
we have to
statute.
mark it.
It doesn't
Okay.
have anymore.
Okay, thanks. So, the bottom paragraph of everything you're looking at, maybe I'll read it, Mr. Sasso?
Please do.
Yeah, no variance or other relief may be granted under the terms of this section, including a variance or other relief involving an inherently beneficial use, without a showing that such variance or other relief can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the zone plan and zoning ordinance.
Okay.
And I assume, just for the record, that you're a boldface on that last,
That was mine.
yeah, okay.
Tell me if I'm paraphrasing it correctly. The bottom line is, you may be an inherently beneficial use, but that doesn't mean that you are entitled to an approval unless you meet the second part.
Yes.
And after Medici, there were several other cases that dealt with the second prong, is that right? In other words, Medici spoke to a different burden of proof, but that dealt with the issue of an inherently beneficial use not complying with the second section. Would you agree?
You got it backwards, but
Go ahead.
yes, there's been a body of law since Medici, but Medici didn't do the inherently beneficial. That was 5 years later with Sika. But, yeah, you're right. You know, what happened was Medici came along and all this other case law kind of whittled away at the strictness of Medici, is the way I would put it.
And then that directly affected cases involving inherently beneficial uses.
Yes, and if I may, lessened the burden on them in general.
On a definition of inherently beneficial.
That's one.
Right. But with regard to the second prong, it did not
So,
reflect
right,
any change.
and that's why you heard my testimony. You're completely
Well, I
right.
did, and that's why I'm going to ask you the basis for that testimony. That in this case, 33,960 panels in the middle of a farming and residential zone here in Bedminster somehow comports with. I think you before said there were things in the master plan that actually supported this application, correct?
Yes.
And you read Mr. Banish's report, as you said, correct?
Yep.
All right. Let's talk about farmland. In New Jersey, with regard to solar energy, would you agree with me or not that the state study that Mr. Banish refers to specifically states that farmland should not be utilized and given up in exchange for solar energy?
So I probably wouldn't agree with you. So remember, this distinction between farmland, non-farmland, and so on is really not my field of expertise. There is some litigation that supports your remark, which is mostly about grid solar rather than net solar, if you...
I didn't make that distinction, though, as you remember.
I'm making it.
No, well, you're here to answer my question.
No, he's answered it.
No, he hasn't.
You just didn't like the answer.
Negative.
No,
I did not distinguish.
but he
Gary.
is.
Yeah,
He
But he
can't agree with you if he distinguishes. You
Let's-
can't make him answer that way.
Let's,
I'm sorry.
one speaker, we'll just, there was an objection. Let's take a minute and just maybe go back to the question.
Sure.
Maybe we could even just read the question and...
I'll rephrase the question. Based on what you've read, including the Energy Master Plan for the state of New Jersey, would you agree with me that New Jersey treats the use of farmland being used up by solar facilities different than other land?
I never read the State Energy Master Plan.
Well, you told us that you read Mr. Banish's report, right? Do you have that handy?
Yes.
All right. Why don't you go to his report?
This is where we have to explain to them coverage.
Yeah.
Yes, so I'm on September 29th, which I believe was,
2014?
yes, that's the last report, Frank? That is. Yes, that's right. Is that what you want?
Yes, sir.
Go ahead.
In his report, and I'll tell you the exact page, let me just find it. He refers to the New Jersey Energy Master Plan, correct?
Page, please.
Bear with me.
Okay. Page 9.
Page 9, 5.2.
Yeah. 5.2 speaks to the New Jersey Energy Master Plan. You see that?
Yes.
In there, he says, in order to meet the burden of proof regarding the public good negative criteria, the applicant needs to address the considerations in the New Jersey Energy Master Plan and potential to locate solar energy infrastructure on rooftops and parking areas rather than the scenic prime farmland. The public good proofs must also address the impacts on the neighborhood.
Right. So I think that's the question.
The question is, did you then review the New Jersey Energy Master Plan?
No. So what happened, if I may, Mr. Sasso, is that
I just simply asked you if you reviewed it.
I can clarify better, or if you just want no, I'll say no.
No, I want you to tell me the truth. So if it's no,
Wait a
then
minute, you
that's fine.
can't accuse him of not telling the
He
truth.
wants to answer some other question,
That's an
Gary.
improper question.
He wants to answer some other question.
No, you said you can't not tell the truth. You can't say that to my...
He said he wanted to clarify. You either read it or you didn't read it. Well, ask
Then
him
he didn't
again, in
read it.
fairness. Did you ever read the 2011 New Jersey Energy Master Plan?
So the answer is no.
Okay. When you saw that comment by Mr. Banish, what did you do, if anything, to determine what the contents of the statewide Energy Master Plan were?
we relied, and this was a deliberate decision, on our first witness on this, who is the expert on that master plan, that being Tom Lynch, to have covered that topic through his expertise. My role was zoning ordinance, master plan, municipal land use law. So we just simply, to answer your question, assigned it to another member of our team.
So he was instructed to read the statewide master plan.
Mr. Lynch lives with it.
Okay,
Okay.
all right. Do you know what it says, though? Even paraphrased from him?
So I know broadly, okay, that 3 of the 5 overarching goals of that document encourage solar.
So I'll read from you from page 107 from that master plan. Although a number of utility-scale solar installations have been proposed for and installed on what were previously working farms, the Christie administration does not support the use of ratepayer subsidies to turn productive farmland into grid-supply solar facilities. To date, public and private entities in the Garden State have spent over $1.4 billion to preserve almost 2,000 farms, covering nearly 200,000 acres. The policy of encouraging the development of renewable resources should not impact the preservation of open space and farmland. While the Christie administration will not presume to limit the disposition of private property, New Jersey should not subsidize the loss of productive farmland. Rules proposed by the State Agricultural Development Commission under the 2009 Farmland Assessment Act update, but not yet finalized, should provide safeguards for property that has been designated as preserved farmland. Other safeguards should be implemented as experience dictates.
Is there a question?
So-
Or are you just reading that into the record?
Well, if you perhaps would allow me to
Well,
ask
excuse
a
me, I
question,
thought you
I'll
were
do
done.
that. Were you aware of that policy?
No, but the policy, if I may, talks about grid. First
Absolutely.
sentence.
What do we have here, by the way?
We have a net meter job for Sanofi,
In what town?
Bridgewater.
Now, would you agree with me in terms of the cases that have evolved through the years, going through Medici, that most of the uses that are declared to be inherently beneficial have been charitable type care?
Have been
Charitable.
No, so SECA is directly on point with that. Many are, you're correct. SECA, in its decision, if you get into the weeds of that decision, say it doesn't have to be nonprofit.
That's not the question I asked you, though, sir.
Say it again, please.
Sure.
Repeat your question.
Most of the uses that have been declared to be inherently beneficial by our courts have dealt with charitable type institutions.
Emphasis on the word most, and then I'd agree with your statement. Yep.
Okay. What do we have here? Is this a for-profit enterprise?
Yes.
Is any of the energy that's being created by any of the 33,900 solar panels, will it be directed and used in Bedminster at all?
Remember, it's now 33,000. I want to correct you on that, not 33,900.
Go ahead.
We lost 900 because of the stormwater adjustments.
Okay.
So the new number, folks, is 33,000. Was the question, will it be, some of it be directed
Will
to?
any of it be used in Bedminster?
Not directly.
Okay. And in fact, Sanofi is a for-profit corporation, correct?
Yep.
What empirical proof do you have, if any, to tell this board as to whether or not the panels could be set on Sanofi's roofs? Have you ever directly had communication with the owners of the property?
No.
You said you walked this site quite a bit, right?
Correct.
Did you also go over to Sanofi like I did?
Yes.
Describe the buildings for the board.
So there are 4 buildings over there. They're tall, typical corporate office buildings with a lot of surface parking.
Surface parking, that could be covered parking, similar to the parking at KDC, with solar panels above, correct?
If a deal and, with ownership could be worked out, That is possible, just the way you see panels out here in the parking lot of this building.
Or, or panels actually put on those huge buildings themselves, would you agree?
So, and remember, I'm trying to help you, okay? But
Don't,
I don't do solar jobs, okay?
okay,
Just,
based on what you've seen.
yeah, just remember, it's not as easy to put panels on a roof as you think it is, okay? There's equipment up there, there's penetration through the roof, there's insurance issues to come in. So maybe that could happen, I think you're right. Maybe it could happen in the form of canopies in the parking lot, I think you're right. But without willing ownership, and this went back to Mr. Lynch's testimony nearly 2 years ago, you cannot do anything.
Okay. Above and beyond that, in terms of driving around, as you did probably at Santa Fe, there's a lot of ground that's basically free, correct? It's a large campus.
It's a large campus. It is encumbered in part by the parking lots you mentioned, by wetlands, and by, I think, one other approval on the property. So you look at it from an aerial photo, I think you're right.
It's huge, right?
Looks like there's a lot of stuff going on. It's all out in terms of available sites, mostly because of ownership, but also because of environmental.
All right. In talking about zones that are appropriate as a New Jersey licensed planner, were you aware of the statute that speaks to industrial zones who have 20 or more contiguous acres?
Yes.
Okay, let me show this to you.
You know what this is, right? Thank you.
Doing here,
Yeah.
Thank you.
Sir, this is 55D-66.11, correct?
Yes.
And this specifically addresses zones, a particular zone that automatically, pursuant to this statute, is ripe for location of solar panels. Is that right?
Yes.
And the legislature did this, correct? This was not done by a court.
True.
It states that a renewable energy facility on a parcel or parcels of land comprising 20 or more contiguous acres that are owned by the same person or entity shall be a permitted use within every industrial district of a municipality. That's what the statute says?
Yes.
And would you agree with me, the footnote to that would be, even if the town in that industrial zone didn't allow solar energy facilities?
That's what that, so what that's doing is taking away that power in this limited instance from the town's power to zone for its industrial zones.
And you would agree with me, the legislature then, by reason of passing that law, made it pretty clear. Look, if it's an industrial zone and if you have 20 acres, we say that's suitable for a renewable energy facility. Would you agree?
Yes?
There's other legislation that I found. That deal with farms and protection of farmland. Now, understanding the difference between farmland preserved and private ownership, because you are private ownership, right? The Kirby zone, the Kirby Trust owns the property.
Yes.
But I understand that difference. But in looking at least the legislative intent, let me show you 4:1C-32.4. Just ask you to take a look at that.
So, we're not marking any of these?
No, statutes are automatically referenced, and you can just talk about them by title. If you think it's not the right version, you can tell us.
No, I just want to make sure you're okay. I don't even know what it says.
It's on preserve, so you can do a little bit of solar on preserve, like 5%, yeah. Looks like their ordinance here is preserved. So what?
We're not preserved.
So what?
Are we?
Yeah, which is into it.
Would you agree with me that that statute provides that if it's farmland preserved land, the only solar that is allowed in New Jersey on farmland preserved land is just for use on that property? In other words, similar to the new ordinance that Gary spoke to before.
So, in all fairness, Mr. Sasso, this is one, you're asking me to read a two-page.
I'm sorry if I, no, please,
This
please,
is not
take your
one I'm
time.
familiar with, the others are.
Sure.
I kind of have committed to memory.
No, not a problem.
First of all, we're not preserved farmland.
I understand that, and I said that already. We're
Okay.
talking about farmland in general, as I said before, without distinction.
So, you're talking about just farmland in general.
Yes.
And so, question, I'm sorry.
Sure.
I'm sorry.
Are you done reading it? I thought you weren't done reading it.
No, I haven't even started. I just.
Okay, just read it.
Yeah. I'll tell you what, you know what, can we take
Good time for a break.
now?
Yeah, great time.
A quarter of will come back, 10 minutes,
Okay.
14 to.
I'm going to lose my break time because I have to read, right?
2 pages I think you can deal with.
I guess I got my.
Okay,
Thank you
we
so
can,
much. Did you hear what was happening there? Can I listen?
Seeking to address all guidelines and standards, even though no one ever said we're going to do that.
okay, we're back. You had a chance to go through that, Mr. Tobia?
Memorized.
He doesn't admit that we need to do it.
Could you repeat paragraph 8? No, I'm only kidding. And then just generally, would you agree with me that New Jersey, our state, treats preserved farmland as being something that should not have solar energy unless it's a net meter situation used for the farm? Would you agree with me?
That's what that says.
Okay. Now, we started talking about the negative criteria, and I told you I would go back to that, and I want to talk about the fence. This fence. What? Give us a description of the fence, and tell us about how many feet it runs along the property.
7-foot high fence. Sasso, chain link. You heard about the fabric. Fabric runs, my pointer around. No, let's see if I can use this one. Fabric runs around areas of heightened concern for neighbors, so if you follow my pointer, please, it runs along the northern edge of the westerly facility, wraps around slightly to the south. It runs along the entire north edge of the easterly facility, and then because of our concern about Country Club Road, it follows a path on the southeast corner of the easterly cluster, and then returns and runs due west along the entire rear of that cluster.
Okay. Now, just so this is clarified, are you showing us where the fence is or the fence with the material?
Fence with the material.
Okay. There's additional fence that has no material. Could you outline that for the board?
It encircles both clusters in their entirety.
Okay. Can you just, again, just give us a quick indication of where we're talking about?
So fence would encircle the easterly enclosure,
Right.
and then fence would encircle the entirety, as I said, perimeter of the west.
Okay, and in terms of the proximity to my client's lot, Mr. Forbes, on that corner, is there going to be any fabric there?
No,
And you spoke about what kind of trees being located in that area?
so, and the gentleman is talking about the westerly edge of the property. Generally, what you find back there are mostly secondary growth. Cedars is the predominant plant material back there, 15, 20 feet high,
We're not talking,
on
Okay.
our property.
right, we're not talking about hardwoods.
Mostly not. You'll
Right.
see a couple scattered in there.
Right, no, I remember what Ron told us.
Right.
Now, in terms of the plantings, tell us where that ends in that area. So let's take the back line of the solar array section closest to my client's property. Can you tell us where the plantings end?
So they basically, I'm going to pull out the map to answer this exactly for you, but basically they run entirely along the northerly property line. Sorry. And you can see it on here if you have an eagle eye, the black line running along the entirety of the westerly cluster, thus, and ending near the northeast corner of the subject property, and they do not return southward along the common property line with your Lot 9, Mr. Forbes's property to the west.
What is there to hide the solar arrays? If you know.
yeah,
You've
well,
walked it many times.
There's the fence, and there's just a lot of existing plant material, and then when you get on the parcel your client owns, that just appears to be solid woodlands.
And you walk onto that lot also?
No.
Oh, okay.
Wetlands too, right? Wetlands.
When you're talking about, when you're talking about the negative criteria and you talk about a microscopic impact on the neighbors, what type of neighborhood is this?
So it varies from single-family residential, which is mostly what you see to the north, to scattered residential, which is mostly what you see south and west.
Any commercial applications, whether they're non-conforming or conforming?
Did you say commercial?
Yes, sir.
Commercial properties, you mean, land uses?
Commercial uses, yes.
Say, none that jump out at me, no.
Well, for instance, and you went to Santa Fe like I did. If you go from Santa Fe and then go to, as the crow would fly, across 287 and go to this area, would you agree with me that once you hit 287, that's it, it goes to residential?
Yes.
Have you ever been a planner for a municipality?
Many years ago, I did municipal work. I have not done any in approximately 15 years.
Okay. But generally, in your role as a planner, both on behalf of a town or on behalf of an applicant, includes a review of the zoning ordinances in that particular town. Would you
Yeah.
agree?
Yes.
Okay. When a town has a coverage ordinance and a town has a impervious coverage ordinance, tell us generally, what does the coverage ordinance speak to?
So in every town, the correct answer is it depends on definitions. Okay, every town changes, as you know. Coverage can mean building coverage, or it can mean total coverage, meaning building plus paving and so on.
But that would be impervious. Would you agree with me?
The latter would be impervious, yes.
So you have to listen to my question. Are you familiar with towns that have ordinances that separate out coverage from impervious coverage?
Yes.
Would you say or agree with me that that's more than half of the municipalities in this area?
No,
Okay. What percentage would you attribute?
I wouldn't hazard it.
Because you're not, go ahead.
The main control, Mr. Sasso, is impervious. That seems to be of greater import to most towns. And there are towns who try and cover coverage also by what I call building coverage, which means how big buildings get relative to the size of the site.
Right, which is why I'm asking that question. When they do have a municipality a coverage ordinance, okay? Does that control, in essence, the intensity of the construction and improvements on the site?
It's one major control, yes.
Okay. In this case, with regard to Bedminster's ordinance, does it refer to both coverage and impervious coverage or not?
So in our town here, we have lot coverage, which is what you and I are generally describing as the non-building coverage, total coverage. That's the 5% control. The other part of your question was what, please?
No, it's really that. In other words, the lot coverage section isn't addressed by impervious? Is that what you're saying?
It is.
Okay, because the definition of coverage in this case includes impervious.
That's exactly right, yes.
Okay. Now, you spoke to a state statute which exempts solar panels from any calculation of a certain kind of coverage. Isn't it a fact that 55D-38.1 specifically only refers to impervious surface or impervious cover?
That is correct.
Okay. In this case, if we go by the ordinance, and you did provide some testimony as to whether you thought that the engineer's definition, he interpreted it one way versus another, what are the numbers for this project versus what the ordinance allows?
5% is the control, 3.59. 3.59 is the control if you exempt solar panels.
Well, that's not, okay. Let's not exempt solar panels because that's not what the statute says, because it speaks to coverage. And I'm asking you, if you include the solar panels, what is that number versus the number provided for in Bedminster's ordinance?
So in the Bedminster ordinance, 5% required with panels, which was your question, 15.9% would be the coverage requested.
And are you saying to the members of this board that that's a de minimis difference
No,
in terms of the variance?
no.
How many percent are you over what is allowed?
In absolute terms, it's 10.9%.
Based on a fixed of 5, correct?
Yes,
All right, so you're over twice what is allowed in that zone. Would you agree with me?
no, it's 3 times.
Okay. That's why I said over twice. But
It's over 3 when it's 15 times 5. That's 3.
absolutely.
Okay.
Now, with regard to the coverage that you're talking about, is there any exemption that you found under Bedminster's ordinance that would allow you to have over 3 times the amount of coverage?
So the answer is no. The only way it would be allowed is through the variance procedures that you and I have been talking about.
Okay. Now, that variance procedure, as we talked about earlier, includes a specific requirement, and the burden is on the applicant, is it not, to satisfy the second prong?
Yes?
In support of your testimony, you relied on the Medici case, which is a New Jersey Supreme Court case at 107 New Jersey 1. In that case, on pages 22 and 23, it says the first prong of the negative criteria requires that the variance can be granted without substantial detriment to the public good. In this respect, the statutory focus is on the variance's effect on the surrounding properties. Would you agree with that statement?
Yes, only Medici does not apply, but the more or less the identical language is in the Sika case, which is operative.
Okay, so
Same
they
basis.
say the same issue?
Yep.
Same thing?
Yes.
And that's a specific burden or a finding that the board has to make, not a burden?
Yes.
And the burden is on the applicant?
Yes.
In Medici goes on to talk about whether or not the granting of the variance will cause such damage to the character of the neighborhood as to constitute substantial detriment to the public good. Would you agree with me that that analysis applies here?
Yes.
Okay. And when you look at the analysis as a planner for negative criteria, what do you look at from the town standpoint to determine what the intent of the zoning ordinance is?
So now we're talking about kind of the second prong of the second test, right?
Yes.
Intent and purpose of the zoning ordinance and zone plan, right? Zone plan and zoning ordinance. And so I look at a number of things, I've mentioned them. The zone says, in this case, you need big properties with big setbacks. Okay, that's one of the things that contributes to rural character in the zone. And I don't want to get through the merits of it again too much because you have questions, but we do that, okay? We have a big piece with big setbacks.
Well, they speak to use, right?
Of course.
What is the use that's described in the master plan?
I don't understand.
In other words, they have certain uses that are the uses that they envision being utilized in the zone.
Yeah, that's real. I think your question is what are the uses articulated in the zoning ordinance?
For Bedminster.
Okay. You said master plan. Zoning establishes the permitted uses. I went through those before. Single-family homes, ag uses, schools, houses of worship, golf courses were many of the ones I mentioned.
But what I was actually asking about was the master plan. You reviewed the master plan. Is there a discussion in there in terms of what the township expects the uses to be in that
And
area?
the master plan is complementary of the zoning ordinance and vice versa. It mentions those uses and more broadly preserving the rural character of the area.
Okay. You also indicated to us that you spoke about soils rather quickly, type A soils. Could you elaborate on what research you did with regard to any designation of soils on the Kirby property as a farm?
I did no soil analysis. It's not my field. I've never done them.
Well, regardless, are there from either the state or the county standpoint maps that speak to farming soil within a district?
The only ones I know of are shown in the local document, the local master plan.
And in this case, why don't you tell the board what efforts you made, if any, to determine if there was a state or county plan that identified the value of the soils on the Kirby farm?
None.
Did you see that notation in Mr. Banish's report?
About?
Farm soils.
Yes.
You read it, and then you didn't do anything about it in terms of research. Is that accurate to say?
No.
Then tell us what you did.
That, first of all, I read it. Secondly, as I explained, that's not my field. Soils analysis, farmland analysis, that's not what I'm qualified to do. I did, in the master plan, look at figure 9, which does map farmlands, okay, and it is, it's a helpful document, and figure 12, which maps forested areas in the community. It's also helpful. And we talked about this as a team, and I commented on what I could based on what I see happening on this site to assess those concerns, especially Mr. Banish's concerns about farmland preservation.
Well, he's a planner, correct?
Yes.
He's Bedminster's planner?
He's what?
He's Bedminster's planner.
Yes.
He's a town planner.
Yes.
And he rendered a report in connection with this case about your client's application. Would you agree with me?
Yes.
In there, one of the things he speaks to is the quality of the soils that are located on the Kirby farm.
Right.
Did you do anything by way of your own investigation to determine if what he was saying is true or not?
No.
Let's talk about the landscape buffer and the landscaping. I think you mentioned flowers, mountain flowers, at some time about underneath the arrays, perhaps.
No, I said wildflowers.
All right, wildflowers. Yes, and you said that your client was an expert in the field of plantings of wildflowers under the arrays.
I don't think I said expert, but so I've seen two of their larger facilities where they've planted wildflowers, and they've got it going. I mean, they have abundant, successful plant material under these panels that vary from flowers to grasses.
How many projects have they done, by the way?
I don't know.
Did you ever ask them?
No.
And you only saw two.
So I saw two, I said, what compares, okay, to Bedminster? Give me some ideas. And those are two I investigated.
I know, but you told us they were an expert, and you said that you've only seen two. Which two have you seen?
The Lawrenceville facility down near Lawrenceville School, and you heard talk of the Imclone facility on Route 202 in Branchburg, pretty close by. And those are the two I investigated.
Did you go to the Middlesex County Correctional Facility?
No.
And that was right on Route 1 when you came up from the Lawrenceville School. Would you agree with me?
No, I came up 206.
Oh, you did? Okay. You like the traffic?
I like avoiding Route 1.
All right. So you have no idea what the condition of the ground is under those panels?
Only because of the transcripts. I have not seen them.
Okay. Speak to me about the zone in question that we're talking about, and how in your opinion, a 30,000 panel energy producing solar plant fits in this zone in Bedminster without damaging or causing any substantial damage to the neighborhood, this residential neighborhood.
This is actually redundant. Do you want me to include it?
What's happening is Mr. Hall and the witness throughout the night they talk to one another.
I object
Which
to
is
that statement.
inherently objectionable. Okay, he's been doing it all night. I'm trying to be
hasn't
nice
been doing
with
it all
Mr.
night.
Hall, who blows his stack all the time at me, but, the bottom line is what's fair is fair. He doesn't need to be coaching his witness, while I'm conducting my cross-examination.
I object to that statement. It's false. Mr. Tobia, tell us what you just asked me.
Mr. Chairman, you are the one in power here,
Well.
with the consent of your attorney. I didn't ask Mr. Hall to now conduct a direct examination of his
You
client.
accused me of coaching my witness.
You've been talking
which
to him
I
all
take
night, Gary.
offense at.
You've been talking to him all night.
No, I haven't. You're lying.
I'm lying?
Yes, I have been talking to him all
Ms.
night.
Donato, what have you observed all night?
I've observed repeated interchanges of conversation. I wouldn't say all night, but I would say it was repeated.
Tom, is this, do you have any?
We should continue. It's a legitimate objection by Mr. Sasso. They should not be communicating with one another.
Thank
All right.
you, Mr. Sass.
But it's
Thank you.
also, it's not as formal as a courtroom, so let's try to move on.
Okay. Would you agree with me in terms of your review of the master plan here in Bedminster that it indicates that the R10 district was created in response to a broad range of local objectives for the countryside portions of the municipality? Would you agree?
Yes.
Okay. And it's your testimony to this board that this 30,000 panel solar energy facility would not be a detriment to that purpose in the R10 zones. Is that what you're saying?
It's 33,000 panels.
33,000 panels.
33, please.
You just knocked off the 960 because of the drainage situation. So go ahead.
So 33 is operative, okay? And so I'm sorry, can you please repeat the?
Are you saying to this board that based on that purpose of the R10 zone,
Right.
that a 30 33,000 solar panel farm
Right.
is consistent and will not injure the intent and purposes of that zone?
Yes.
Okay. In terms of the requirements in the R10 zone vis-à-vis density, did you determine when you reviewed the master plan why it was that they would require such large lots based on the intent that was spelled out in the master plan?
So that is explained in the master plan. Excuse my noise here. And, the broad reasons were to preserve rural character, to preserve farmland, to protect environmental features, to protect streetscapes, vistas, and so on.
Okay, well, let's add another one. How about to preserve farmland and promote the industry of farming?
I said that in so many words, yeah.
In so many words? Okay. Tell us what it is about this 33,000 panel solar plant that preserves farmland and promotes the industry of farming.
So it, first of all, holds steady, if you will, the amount of ag production on the site, meaning that front portion near the intersection. It continues the important visual, okay, of agricultural activity along Country Club Road, a little bit toward Meadow Road also, but mostly Country Club. It removes no soil, okay, no soil export, and it recognizes, Mr. Sasso, that the back half of this site is not in prime agricultural activity now and has not been for years.
Okay. Do you know the reason why that is?
No.
Did you look into it?
We asked the person now hanging this piece in part of our preparation, why? And the answer was it's been in woodlands for years because it's not worthy of being farmed.
Do you have any investigation, any facts upon which you can rely to support a statement before this board that that farm with the designation of soils that you see in the master plan cannot be fully utilized for farming if an active farmer went in there next week?
I don't think anyone could do that without investigating the soils on the site.
Well, you have
And
maps.
I have not, if I may, I have not done that.
Okay. But you're going to come here and say that with regard to this farm, it preserves farming based on the little bit of hay that's cut in the area alongside the roadway. That's what you're telling us.
Good question. That's what, that when you say a little bit of hay, that has been the ag activity on the site for a long time.
Right.
And
But I guess
yes,
the real question is whether or not there could be significant farming on the site and whether you can even answer that question before this board.
So I think the good answer to your question is I cannot answer that question.
Let me ask you this. With regard to the district that it's in, do you know anything about the Somerset County Agricultural Development Board, CADB?
No.
Did you contact them at all in connection with your evaluation of the use possibilities for the Kirby Farm in connection with this application before you came in here tonight to testify?
No.
You told us that you looked at the attachments to Mr. Banish's report. Did you see that in terms of the particular soil that's on this site, that it's characterized as highly productive farmland soils?
Yes, I saw that.
Okay. And that meant nothing to you in terms of you rendering the opinion that you gave us tonight, correct?
No, that's unfair. I respect his remark. I recognize that there may be that kind of value to this site, and I gave you a few reasons, a few bullet points as to why we're not being substantially detrimental to Mr. Banish's remark.
Okay. As I said, you cannot answer the question whether or not it could be fully farmed on this highly productive soil or not, as you testified before us tonight.
I said that already.
Okay. Address the issue in the zoning ordinance in terms of open space vis-a-vis this project with 33,000 solar panels. How does that in any way comport with the intent under Bedminster's ordinances and master plan to have open space in this area?
So Bedminster has an open space vision by preserving this rather massive perimeter of setbacks, buffers. You do create open space around the outside of the property that, as we've looked at it thoroughly, convinces us, and me, I should say me, that the appearance of open space along Country Club Road and Meadow Road, that visual, will remain an open space asset to the community.
You're telling us that what we already see as we go down the roadway as open space will now be preserved because you're going to put a fence behind it. That's your rationality.
It will not be preserved. The fence will be one contributing element, yes.
And you'll be able to see the 7-foot fence that's running for 1,000 feet as we're going down the roadway, correct?
No,
Okay, tell us.
landscaping will be on the outside of the fence.
Well, we know there's no berm. One of the changes that were made, because you're so familiar with the project, is that the berms up front alongside the corner have been removed, correct?
That's because the panels were moved all the way back.
Okay. And from the street, are you testifying to something other than what Mr. Kennedy said with regard to whether or not the fence is visible around the outside of this project?
No, I think the testimony is consistent.
Okay. I'll ask you the question directly then. As I walk around this project, and you can use your red pen or not, go around this project, will I be able to see the 7-foot tall fence?
So I have no doubt there will be glimpses of it, depending on where you're walking. In the areas of high sensitivity to us as designers, you will see mostly plant material rather than fence.
Okay, so the answer is that you will be able to see the fence in areas.
You heard what I said.
Right.
You heard what I said. Not all over the place. You might see isolated views, and mostly what you'll see is plant material on the outside, which will cover most of it.
Even though in certain areas there are no plantings. We already established that.
Sure.
And there are no berms, correct?
Yeah, mostly at the input of the board, yes.
And you're going to say that they did it?
The sensitivity to the berm issue, let me get out my pointer.
Sure.
Was
Why
that,
don't you point to Mr. Forbes' area and show us where the berms are?
that's already been asked and answered.
That's right, and there are no berms, correct?
Right, because of the dense vegetation in this area and the big setbacks, which, by the way, Mr. Sasso, I said we're 240 feet from that common property line with your clients, but they taper back, so you have wider setbacks than that as we move away from the property line. But back in this area, when we looked at what's out here now and what happens on your client's property, which is undeveloped woodlands, you have a heck of a lot of a visual barrier looking from the west toward this site.
And in testing that theory out, and you told us about certain areas that were checked, a few areas on the map where the engineer actually went out and checked. How many checks were done along that line of the project?
First of all, it's a question for the engineers. I believe the answer is none.
That's correct. That's all I have.
Thank you, Mr. Sasso.
Thank you.
Ms. Donato, would you like to come up?
Good evening.
Hello there.
Before I get into my questioning, the general questioning, I just have a little bit of confusion about what you stated, the Medici case actually stated. Did you say that Medici was a particular suitability case?
So Medici said for the D1, the commercial land use, that applicants must prove that the general welfare is served because the site is particularly suited to the use. I think that's what I said.
Yeah, but isn't Medici really a case about the enhanced quality of proof that is necessary for a D1? Isn't that really what was the pivotal? I mean, we've had particular suitability since the Cole case, which was way back in ancient history. So that's been the law of D variances for years. Isn't that correct?
Yep, that's good. So Medici revalidated Cole, if that's a good way to put it. And then I think the new addition, the major contribution, was the enhanced burden of proof. I think you're right.
Okay. And then when the courts whittled, they whittled the other D variances that didn't necessarily have to meet the enhanced quality of proof regarding the master plan. Wasn't that really the pioneering statement of Medici rather than particular suitability?
So you're talking about like Burbridge, Coventry Square, Randolph, right?
Yes. Okay. Okay, now, do you agree that the character of this area of Bedminster Township is what is described as countryside?
Yes.
And are you aware that Country Club Road is identified as a gateway in Bedminster's comprehensive farmland preservation plan?
Yes, the gateway is described as the entry point from Bridgewater moving north. Yes.
And isn't that same classification also applicable to Meadow Road? Scenic, this is considered the gateway to the southern country area of Bedminster Township, is it not?
No, we could check with Mr. Banish. I don't remember it that way. I do remember, Ms. Donato, them both being described as scenic roadways.
Well, did you review Bedminster's comprehensive farmland preservation plan in connection with your testimony?
That's the document in the master plan?
Yes.
Yes.
You did. So did you look at page 3, which states that they should protect gateways into Bedminster County, Bedminster specifically referring to Country Club and Meadow Road?
Yes, I did, sure.
Okay, so you agree that both of those roads are considered gateways?
No. I think Country Club was gateway. I think Meadow, and I might be wrong, I could check on this. I think Meadow was importantly described as a scenic road or a scenic corridor, and so was Country Club. But Country Club has that rather romantic moment in it where it says when you leave Bridgewater and you head north on Country Club, you have this scenic gateway, this great sense of arrival into the rural countryside. But I think it was only mentioned for Country Club.
All right, well, we'll stand by what the Farmland Preservation Plan states, but the question I have for you is, doesn't that distinguish this particular area of the township from the many other thousands of acres that this township has so diligently sought to preserve over the course of years?
I'm respectful of what was said about these two roads, but I think they can be said about many roads in Bedminster. I don't think there's a significant distinction.
So you just disagree with the long-term planning goals of this community?
No, I didn't. I said, let me put it a different way. There are a lot of other roads in Bedminster that look just as lovely as this one.
I started out with Gateway, and you decided to merge Gateway and Scenic. So let's stick with the Gateway for a minute, okay? The fact is that the Farmland Preservation Plan calls this a gateway. Whether Meadow is included or not, which I believe that it is based on my reading, we'll deal with that later. Gateway is different than Scenic. You agree with that?
Yes.
Okay, so let's stick with that for a moment, okay? So this particular area being a gateway to the countryside of this community, okay? differs from the general rest of the countryside in this area because of this characteristic.
I follow that. Yep.
You agree with that?
And I agree with that. Yep.
Okay. And you agree that both of the roads are scenic corridors, both Meadow and Country Club?
Yes.
And isn't it true that this intersection of Country Club and Gateway, Country Club and Meadow, is referred to in the farmland plan, that this scenic gateway is, quote, no more evident, close quote, than in this location?
Yes.
And that matters not to you as a planner when you talk about coming into and looking at the negative effects of this particular proposal on the intent and purpose of the zone plan and master plan.
It matters greatly to me.
So that the fact that this is, you didn't mention gateway in your testimony, you didn't mention scenic corridors in your testimony.
So I didn't use the term gateway. Hold on one second. So let me clear it up, because I think you're right. If you go page 159 in the master plan, folks, it says, in this regard, no gateway is a more intriguing study in contrasts to the traveler to the traveler that experiences crossing Chambers Brook, that's where Bedminster is, from Country Club Road, Meadow Road, or Airport Road. So they are mentioned all as gateways,
Right.
even airport.
Right.
Now, I did not neglect that. I recognize that, and I agree with that assessment. The long and the short of it is everything you see now on Country Club or Meadow, recognizing that gateway approach stays the same visually. That was part of the ultimate design of this layout.
Have you ever seen a plan that shows the existing and proposed vegetation from various points of view from these roadways, shows that plan, and shows what you actually see on a four-season basis?
You talking about a rendering of some sort?
Yes.
So, yes.
Has it ever been presented to this board? I'm not referring to the cross-sections.
So I was going to say, the only way it's been presented is through cross-sections,
Okay.
my knowledge.
So something that actually shows the type of trees, their planting, their spacing, that's not shown, is that correct?
It is shown also in plan form on our landscaping plans,
Okay.
of which there are 6 in the plan set.
Is the proposed vegetation that is part of this application, and this fencing, this 7-foot fencing with the material on it, is that the scenic vista that the master plan seeks to preserve?
No.
Okay, thank you. Now, have you also considered vista not just roadside, but also vista from a distance?
Yes.
You didn't mention that in your testimony.
I was waiting for you.
Well, appreciate that. Thank you. So you do know that many people travel to this airport and they view this site from a distance?
Now, are we talking about a distance on roads as we pass by to get?
No,
to the
I'm on an airplane and I go into this airport.
Go ahead.
Well, I think there's, how many, 30,000 people a year that travel into this airport, as I understand it?
I don't know the number. Go ahead.
Those people also have a distance view of this particular site, do they not?
Are we talking about an aerial view?
Yes, an aerial view.
I could see that, yes.
Yeah. So all of the 7-foot fence with the fabric and the nursery grown stock, that's something that's not going to help those who are flying over the site.
I would agree, and if I may, you know Sika probably better than I do. That's true, okay? Someone's going to look down and see panels. I don't think there's a way in the world you convert that legit observation into something that's a substantial detriment caused by this facility.
That is your opinion. Isn't that correct?
Yeah, that's why I said it.
So there are others who may differ. Isn't that correct?
I don't want to argue with you, that's my firm opinion. And if I may, those same folks are flying overhead and they might see Route 287, which
Fine, but the
You know-
287 is there. It's not, the township doesn't control 287, does it?
they might see office buildings in Puckerman. They might see Bridgewater Mall.
We're not talking about that, Mr. Tobia. Let's stick to the issues. If you answer my questions, we may be finished the next time we come back.
So the answer is pilots may see it. I don't consider it a substantial detriment at all.
You don't consider it a substantial detriment that those driving down the road no longer see the farmland vista that the master plan has attempted to preserve?
Incorrect. I said they will still see the exact, or more or less the exact streetscape that they see now.
Are you saying to me that the human eye doesn't see beyond 200 feet?
No, I'm saying it certainly does, but when you add in fencing, landscaping, contouring in some areas, when you save trees, and when you cleverly locate panels on the site with massive setbacks, the human eye will not see that.
Let's differentiate between seeing the panels and seeing the newly created landscaping and fencing that will be that's proposed in order to block the view of the panels.
Right.
There's a difference, is there not?
It's a difference, but what was described still contributes to streetscape and a positive visual environment for the area.
But it is not the countryside vista that the master plan has identified and so strongly identified in many, many sections.
The countryside vista, let's break it down because it's a great question, is not just about big open fields. If you read the master plan, countryside vista can also be achieved by tree-lined streets, by hedgerows, like you see on Meadow.
On the little corner up on the northeast corner.
So one example of it, you're right, is the frontage along Meadow, more or less slightly west of Country Club Road, and then continuing all the way down. Now, so when you look at that, and I'm assuming I assume you've been out there, when you look north from there, you don't see a big open field and a big scenic vista. What you see is a tree line and a shrub line, a hedgerow in that area. That contributes also to vistas. It's just different. Fences, if I can just finish up, because you made a good point. Nice fences might contribute, stone walls might contribute, old houses, and also big open fields.
200 feet, okay, is what you're saying you're proposing as your minimum setback. That is a setback for a permitted use, isn't that correct?
Yes.
And you think a non-permitted use should have the same setback as a permitted use?
Yes, because don't forget, your permitted uses in the zone can achieve massing up to 35 feet or even 50 feet if you're a church. And I looked at that, and our engineers looked at that and said, wow, if we can screen and buffer and protect homes with 200 feet, you sure can use that same setback and shield 5-foot high panels.
Have you ever seen a visual other than the cross-section which will show what travelers on these two roads will see if this work was approved and built as proposed?
So we have cross-sections in the record.
I asked you other than cross-sections.
So what?
And the straight line plan. When you look, haven't you ever been involved in an application where somebody puts something on a plan and when it gets built, it doesn't look like what it's supposed to look like? You've never heard of that?
Only the ones I have not worked on.
That's a little pompous, I would say. Okay, we'll leave that. We'll leave it.
I've looked at the cross-sections, and I've looked at this thing in plan view, and I've examined the grading plan. So there have been a lot of elements that I have looked at to figure out what visual impact would be.
Okay. You do know that this township has engaged in planning efforts to save this countryside since at least 1965?
Yes?
And that the planning board back in 91 identified the need to preserve this area and this site. And you know that they traveled all the way up to the appellate division and won the first major case that involved large lot zoning in the Kirby case, am I right?
Yes.
And you know that in that case, the appellate division recognized, enforced, and allowed this community to have this zoning for this site over the objection of Kirby.
Yes.
You know that?
Yes.
And you know that the Kirby Trust, or whatever entity Kirby has that owns this property, purchased this property for development purposes.
I did not know that, but it makes sense.
And did you know that before the ownership of this property by Kirby, the entire site was continuously farmed, including the back area?
No,
You didn't know that, did you?
no.
And you do recognize that this township's efforts to preserve its countryside and its farmland has continued unabated since 1965?
Yes.
And the R10 ordinance was adopted in 1994.
Okay.
And are you aware of how the State Planning Commission viewed this township's planning efforts in this regard?
I don't know what that means.
The State Planning Commission reviewed this township's through cross-acceptance process.
Oh, okay, yes, yes.
So let me just make sure, maybe if I preface this. Do you recognize farmland preservation as a valid planning objective?
Yes,
And do you acknowledge that farmland preservation is necessary for the sustainability of our society in terms of being able to eat product that's grown on the land?
yes.
Okay.
In the same way I see solar as a sustainable contributor.
So you realize we have two public goods. We have solar and we have farmland. And they're having a head-on collision on this piece of property, aren't they?
Great.
So you also know, based on a cross-examination from Mr. Sasso and the report of Mr. Banish, that the state of New Jersey is not really fond of the idea of putting farmland, putting solar panels on farmland, whether you want to call it grid or not. It wasn't a recommended conflict that they really liked. They didn't like it.
So I have an answer for that, and it's quick, okay? Solar is inherently beneficial. You have the Cox volume in front of you. It's indisputably mentioned as a inherently beneficial land use and defined as such without any distinction as to whether it should be on farmland, net metered, grid, or in any other zone. It's a simple definition. It says solar is inherently beneficial. And I think that's very important for this case. This is farmland, I understand. Master plan says it, I understand that. There's a little bit of farming activity going on the site. Solar's inherently beneficial. And it contributes as well as all these points you're making, which are totally legit, okay, about scenic vistas being important and farmland being important. Solar's important too.
And I don't think anyone's disputing that solar is important. The issue here is whether solar belongs on a farm that is identified in the master plan and efforts by this township having been made continuously since 1965 to save the farmland. Do you have any idea the amount of farmland that this township has preserved since then?
So the master plan identifies it in one section as 2/3 of the community. And I don't know if that's preserved, but it's assessed. It recognizes that it's a big part of the assessment.
So even, I know that the farmland has never been determined to be inherently beneficial, but it is a public good. A necessary public good, is it not?
Yeah, Nice distinction, though. I agree with you. Public good, not inherently beneficial, absolutely a public good.
So you're aware that this controversy between farmland and solar has occurred in other communities in New Jersey, right? Familiar with some of the cases?
No, well, so I'm a little familiar with it. I am not familiar with case law on the topic.
Oh, so you don't know about the Garden Solar case involving Raritan Township then?
No,
You don't know about the cases down in Greenwich and Woolwich Township down in New Jersey?
no.
So you're not aware of the fact that in
I have
several
said he didn't know, so I think you that ends that
But
question.
I'm a little curious. I know you're very well prepared, and I know you always like try to get everything done the right way. So you're coming to a community with a more than 50-year history of farmland preservation, and you don't know any of the farmland preservation cases. You don't go to the farmland preservation plan. You're just basically saying that this is just a little drop in the bucket and it doesn't matter.
So that's a plainly unfair characterization of what's now 2.5 hours of testimony. My discipline is not in farming, it's not in ag, I'm not a farmer. You know why I'm here. You know what I do for a living. And this is my role in this case. And my role in this case, Ms. Donato, says maybe we could find a happy compromise here that treats the perimeter of this property as farmland, open space, vista sensitive, and still provide a tremendously important, inherently beneficial use on the property. So what I'm saying is maybe both, you're saying they're at odds, okay? Maybe they both can be achieved at the same time.
Are you familiar with the Solar Act of 2012?
Ask away, I don't.
You're not familiar with it.
I don't, if you ask a question, maybe I am, I don't.
So are you aware that the legislature actually, in response to the State Energy Master Plan and the concern about destruction of farmland,
Right.
put limits on the number of applications that can be approved on farmland for solar facilities?
Okay, so the answer is yes. The answer is Tom Lynch, our first witness, is the expert in that field and contributed what he needed to on that topic.
So you're not balancing the public goods of farming versus solar.
Yeah.
Solar trumps all. Solar trumps all.
And that's unfair.
I'm asking you, that's what it sounds like.
Yeah, and the answer is no. I have balanced. I told you we're doing solar. I told you we're protecting the perimeter of this property. Our ag yield before and after this job is completed, if it's approved, will be roughly the same, which is 12 acres of cultivation.
So before I go into some of the more meatier things, I just want to get to this particular issue. So property owner buys a piece of property. The piece of property is entirely designated as either prime agricultural soils or soils of statewide significance. And they choose not to farm that anymore, because that's what happened with Kirby. So by virtue of their choice not to farm it, therefore it's not a valuable farm.
I would still say it's not a valuable farm. It might still be a valuable farm asset, meaning the soil is still valuable.
Mm-hmm.
There's nothing that I read in zoning and master plan documents of this town that say you must farm.
Of course
Okay.
not. They can't really, well, maybe the day will come, but they can't really compel. I understand that, but that's not my question. Let's try to stick with what my question was, okay? Could you reread my question for me, please, so we can try to stay on where I was going? And we're very fortunate. You have one of the best court reporters that I've ever dealt with. And the poor woman went through years with me on
We
something.
get credit for that, not that.
She's fantastic. She's really, really good reporter.
Drinks,
Yes.
how can you go wrong?
We're
And she's
paid to be
fast.
here.
She gets them done quickly, too.
Hold on, she has to read.
Can you reread that for me?
You have to stop talking.
Thank you. I take back all my compliments.
Sorry.
So before I go into some of the immediate things, I just want to get to this particular issue. So the property owner buys a piece of property. The piece of property is entirely designated as either prime agricultural soils or soils with statewide significance. And they choose not to farm that anymore because that's what happened in Kirby. So by virtue of their choice not to farm it, therefore it's not valuable farm?
That was my question.
Right. And my answer is, that's a choice. I'm going to answer it the same way I said before. Nothing compels them to do it. That does not mean it's not valuable.
Okay.
Nothing compels them to do it.
Okay, that's all I want to know. Now, I want to direct your attention to the properties on Somerset and Preston. Now, if you go up to those properties and you look over this site from that area, what do they see?
So right now, along that common property line right there, from Preston, shown thus, upper right, and moving westward to Somerset, shown near the center, upper center of the exhibit, you have 4 homes. Right now, there is a nice established tree line here, mostly deciduous plant material, 30 to 50 feet high, I would say. And it's a nice dense screen at the property line with plant material on both sides of the common property line from 200 feet back into the site, right at the beginning of the array, looking at these homes at this time of year. You can barely see any residential structure. And really, Ms. Donato, there are 3 homes in question. The one to the west of Preston, Lot 4, Block 67, Lot 4, and then the 2 that flank Somerset, so indicated. So the answer is, you see an existing tree line.
And that is that a deciduous
Like I
tree
said,
line?
mostly deciduous, but there's some evergreen stuff in there.
So for many months of the year, they see through this tree line?
Generally, the number is 5 months, foliage down, 7 months, it's up.
Okay, so
Roughly.
for 5 months, they are able to, they just have some evergreens there? I mean, have you analyzed what the view that they currently have without the plants in full, in growth?
Without the plants?
Yeah, without, when they're not in the off-season for the deciduous.
Yeah, I see. So, yes, they'll be able to see through into the site. You still, when foliage is down, you still have obstructions. You still have some evergreen in there. You still have some scrub. You have the bases of the trees, but you will be able to see in through the site.
Okay, and after the site is developed, if this is approved as you proposed, what will they see then?
They will see a berm, a fence, and that rather long list of plant material I described earlier, in addition to all the plant material that will stay on that property line, because none of that's being removed.
So they also will not have the same vista that they have. They're going to be looking at a berm with a fence on top of it, right? Instead of a vista.
Right now, from that angle, I would not characterize that as a vista. There's a partial obstructed view in the wintertime of a field in modest condition. Afterward, though, I think you're around your foot line or, a little bit north of that, you're going to see a lot of new plant material.
Let me ask you this. How far does the human eye see?
I don't know, I'm not an ophthalmologist.
So then, how do you know whether the 200-foot is going to really virtually block everything? You're not going to see anything.
200 feet has been deemed an appropriate setback by the Bedminster zoning ordinance.
That was not my question.
Well, it's one way I know.
That was not my question, Mr.
One
Tobin.
way I know. It's been deemed an appropriate control for buildings 35 to 50 feet high. So now, obviously, we can all see more than 200 feet. I don't know the scientific number where that vision ends.
Are you aware that this site is located in an environmentally constrained area under the Highlands Plan Area?
I could see it would be, yes.
Okay. And do you know why it's environmentally constrained?
The area is characterized by water bodies and wetlands.
And are you aware of anything else? For example, habitat value?
No.
So did you read the Highlands Plan with regard to its characterization of this site as environmentally sensitive?
No.
Did you look at the Garden State Greenways plan with regard to this site?
No.
So you're not aware that that particular document characterizes this site as critical habitat?
I'd object. He said he didn't read it, so he's obviously not aware of what it may say.
Well, if this site is characterized as critical habitat, that has no bearing on your testimony in terms of the negative criteria? Substantial detriment to the public good?
All I would tell you is the topic has been explored. That's not just my...
Who by whom?
By an EIS statement prepared by this applicant on file, Amy Green, and it's not my field.
Okay, fine. So you didn't consider that as part of the negative criteria in your testimony?
It's not my field.
Okay. Are you aware of the fact that this particular property is also in Planning Area 5 under the state plan?
Yes.
Are you familiar with the concept of fragmentation of farmland?
Yes.
And are you aware of the fact that these state planning agencies have expressed great concerns about the fragmentation of farmland in this area?
Yes.
So they don't want the contiguous farmland to be developed for purposes that would not be farmed.
I understand.
Okay.
Half of this, remember, even in the master plan locally, doesn't show it as farmland. It shows it as wooded. And if I may, just to clarify that, because it's a good question, this does not have a lot of continuity as you move north and west in this community. It's abbreviated by a residential neighborhood to the north, by 287, of course, and by the fact that half of our piece is not farmland. It's heavily wooded right now.
So you basically just disagree with these state planning documents that you didn't review in connection with your testimony?
I'm not recognizing that question. I don't even know what it means.
You didn't review them,
Right.
but you seem to think that this particular parcel doesn't fall within this idea of having a targeted farm or not having fragmentation.
You asked me with one of the documents if I was familiar with large blocks of contiguous land. I said yes. It's even in the master plan.
Yes.
I'm merely saying this site really doesn't fit into that goal.
Are you aware that this site is a targeted farm under all of these farmland preservation documents?
It's targeted as prime ag soil, as farmland and farmland assessed soil. So yes, I'm familiar with that.
But you're saying that doesn't matter. I mean, look at Mr. Banish's report. He points out that this is priority farmland, that it is recognized by all of these resources as being a site that should be saved. Class A, it's the highest priority rating for a farm that should be saved. And you're saying it doesn't matter?
I'm not saying it doesn't matter. I'm saying we've applied a great deal of consideration to that goal. I'm saying half of this has not been farmed for decades. I'm saying the other half is getting hayed once or twice a year, Ms. Donato. This is not active farmland. It's getting hayed, let me finish please. It's getting hayed once or twice a year. I look at it and I respect tremendously the visual importance of farmland, okay, because it looks pretty every place in town, and that visual will be retained if this is approved and built.
The visual of looking and seeing 200 feet at the smallest and seeing a fence, a chain link fence, that preserves the vista of a farmland?
Yeah. So I'm going to repeat it again. Fence from these vistas will be planted So the fence is really more the last line of defense. What's first is distance as an obstacle. What's second is topography as an obstacle, then new plant material, then the camouflaged fence with the green screen.
And the new plant material is not a countryside vista. We went over that because the vista is a farmland vista that the township is attempting to preserve, not some plants out of a nursery.
We did discuss that already. If the board wants me to repeat it, I will. Vistas come in different ways.
And you're proposing to change the vista. We went over that. We'll just leave it what it was. We don't need to go back there again, okay? Are you aware whether there are any assessed farmlands near this site?
The majority of this area appears to be in farmland use. I have to assume it's assessed as well.
So wouldn't you say that this site is predominantly bounded by farmland?
I'll say it cautiously, I haven't looked them all up in tax records, but they do give the appearance of large pieces of farmland.
Now, I know Mr. Sasso asked you about the Somerset County Agricultural Development Committee. Did you say that you hadn't looked at their studies with regard to this site and other areas in Bedminster Township?
No.
You did not look? The answer would be yes, right?
I did not.
I'll refresh it so we don't have a double negative.
Yeah.
Did you look at the Somerset Agricultural Development Committee Comprehensive Farmland Preservation Plan?
Thank you. No.
Thank you. That reminds me of another double negative I have to get back to when I get to that page. Okay. So you did read Frank Banish's report. Isn't that correct?
Yes.
So you're aware that Mr. Banish did quote from the SADC and plan. All right?
Okay.
So you're aware that that's that concept of fragmentation that they are advancing, that the necessity is to retain large masses of viable farmland.
Yes.
Okay. And you know that this area is also in the Upper Raritan Agricultural Development Area?
No.
You didn't know that, and you didn't look at those documents either?
No.
Have you looked at why the township, county, and these various agencies have classified this site, Lot 10 of this site, as a targeted area with high priority?
High priority for?
Acquisition and farming.
I did not see the acquisition part.
I mean, at farming, what happens, you know what happens if you're targeted under, what happens when you're targeted?
So you're talking about preservation?
Of farmland, yes. So when you're targeted, I'm sorry, go on.
No, go ahead, you go, sorry.
When you're targeted farm, you are a primed farm for acquisition, for preservation of whatever type it is, whether by easement or direct purchase.
Right. And so we know of no attempts for that to happen on this piece?
That was not my question.
Give me a question.
My question to you was that as a targeted farm, it is a very highest priority class for acquisition for preservation as farmland.
I don't think that was a question.
So,
I think it was a statement, but...
Are you aware, I said?
and the answer is no. And Mr. Nato, I got to tell you, if you don't mind, you know what I do for a living. I think you know I'm not a farmer, nor a farmland expert, and my testimony was here all about master plan, all about zoning, and this line of questioning has gone really into ag and farm, and, you know, I've given you some foundation on it. I don't.
Well, I just want to say this.
Mr. Sasso, it's not your turn.
Objection by his own attorney.
It's not your turn. Mr. Sasso.
Farming is a use.
Mr. Sasso.
Farming is a use.
You're directed to sit down, Mr. Sasso.
Okay. I might be reading a different report, and I might be looking at different master plans, but it's rather obvious to me from Mr. Banish's 3 reports that farmland preservation is an absolutely integral and prime goal of this community. So you come to testify about solar, and you don't know anything about the prime goal of the master plan, to preserve farms?
I object. He said he listed that as goal.
I did, and I addressed it as best I could, and you heard that, okay?
That's fine. We'll leave it at that.
Let's move on.
We'll leave it on. I will. Thank you, Mr. Collins. Now, with respect to the goals, other goals of the master plan, there were several I think that you did not mention. I know you indicated you didn't look at the habitats, okay? We've discussed the scenic value. You're aware that open fields and pastures are supposed to be preserved. That's one of the goals of the master plan. Rolling landscapes are supposed to be preserved. You're aware of that?
Yes,
Farmland is supposed to be preserved. You're aware of that?
yes,
Natural resources are supposed to be preserved.
yes,
And they're supposed to retain productive agricultural land in contiguous parcels.
yes.
Can you tell me how this proposal advances the goal of retaining protective agricultural land with contiguous parcels?
I've been over that 5 times. 5 times.
Your answer to me was, they're not farming it, and so therefore, is that your answer? They're not farming it, so therefore it doesn't...
There were a few responses. 1, half is not being farmed. 2, the front is being lightly farmed. 3, we explained early on, a while ago, this property, there's no soil export. I mean, the worst thing you can do with a piece like this is remove soil. We're not doing anything like that. We're doing minimal grading to this site, so we're not disturbing any farmland in terms of, regrading the entire property. And importantly, in that front corner, we are continuing farming, which roughly, Ms. Donato, equals what the cultivation activity is on the site now.
I understand that, and we went over that. So your position is that if an owner chooses not to farm land that is characterized by every agricultural agency and this township as being highly productive agricultural soils, therefore it's not valuable farmland. We went over that.
No. Did not say that. But I did say it's the property owner's choice whether they want to farm or not. It does not, the inactivity does not mean it's not prime land anymore. I agree with you there. But no part of the ordinance says you must farm.
I understand that, but that's not my question.
Keep changing that.
It's not my question.
Repeat the
My
question.
question to you is, if a piece of property such as Lot 10 is evaluated and designated in every farmland plan that you can find applicable to this area as being valuable farm that should be preserved and targeted, the fact that the owner has unilaterally chosen only to farm a portion therefore takes it out of that master plan goal of preserving farmland.
I did not say that at any point.
Good. That's better. That's good. Now,
No, I just want to say, we'll do 10 more minutes, and then we'll try to wrap it up.
okay.
And continue next time.
Oh, thank
Does
you
that
so
work for
much.
you?
Oh, that's just fine. Thank you so much. Okay, so you didn't do any environmental evaluations. I'm not going to ask you that. You're aware that the farmhouse is a historic homestead?
It's recognized by the master plan that way.
Okay. Do you know what's going to happen to the farmhouse?
Plan is to leave it on the site.
While it experiences demolition by neglect?
The plan is, if this is approved, to make it presentable and leave it there as a contributing structure to the streetscape.
And if the plan is not approved, it will just be continuing to deteriorate in sight.
That's up to the property owner, because
Yeah,
we
I
won't be
don't-
here.
I don't know.
All right, I'd like to get to the Sanofi issue. Now, everything that you said about Sanofi's site not being able to be utilized itself is based on a hearsay statement that you got from Mr. Lynch, that Mr. Lynch allegedly got from somebody from Sanofi?
It's not a hearsay statement, it was sworn testimony that summarized his negotiations with property owners on that piece.
He testified to a hearsay statement by somebody from Sanofi. Isn't that what he did?
You're asking for a legal...
All right. So you don't have any direct information as to why the Sanofi site cannot be used for solar installations.
So the only direction I have, is the testimony offered before this board nearly 2 years ago now.
Okay, that's it. Did you ask whether or not there were any other alternatives?
I asked, as part of my reconnaissance, about the on-site use at Sanofi. That was a question that was cleared up during testimony, and then we came to the conclusion this site, the subject property here before the board tonight, is the next best alternative.
Did you look at any other alternatives?
Me?
Yes.
No.
Did you ask your client to look at any other alternative sites?
No.
Did you ask if there were any alternative technologies that could achieve, renewable energy production for Sanofi?
So again, this is outside of my field of expertise. Simple answer, I absolutely did not do that. I wouldn't even know how to answer the question, ask the question.
So, were you asked to participate in the selection of this site before it occurred?
No.
Okay, so you came afterwards.
Yes.
Thank you. Okay. Now, in your direct testimony, you said that the panels are hidden from public view and the neighbors' views, right?
Correct.
Okay. So you do acknowledge that the fences are not hidden from the neighbors' views and the public views?
They make it able to screen the panels.
Okay, but they're there to screen the panels. The fence themselves is chain link fence with fabric, something that's characteristic or contextually sensitive to an agricultural countryside area?
So I think the green mesh certainly does that. The solar ordinance certainly asks for buffering. And, you know, it contributes. I mean, I'm not saying there's a historic element or a rural element, but it gets the job done visually.
You get the job done by looking at a 7-foot chain fence with mesh, rather than looking at
Ms. Donato,
a farm.
wrong again. You get the visual and the protection by looking at plant material, by this topo thing that we've talked about, how the grade changes, and as an insurance policy, maybe that's the best way to put it, the fence.
Well, the fence, let's be honest, you already said the fence is there because of some electrical code.
No, the fence is there, it's absolutely required by electrical code,
Okay.
and it does have a secondary purpose of screening.
Okay, but it's there, they have to have the fence.
Correct.
Okay. And I'm not going to go back over the vegetation. The vegetation is not the vegetation that's there now. You're adding vegetation, creating a different vista than currently exists.
We're using existing plus new.
You're changing the existing vista that currently exists, aren't you?
I don't know how to answer that. I think it's,
Did you read the testimony of Mr. Kennedy?
of course.
You know that he admitted that it changes the vista. It's not the same vista.
That, I believe, was testimony when we had a berm and plant material on the front corner piece. And then he was right, yeah, then, you know,
Just take a look again. We'll check.
that open
We'll check.
field is being eliminated.
Well, we will check. I'm just trying to eliminate everything that Mr. Sasso asked, so I appreciate your bearing with me. I'm a little bit confused, changing. Have the plans changed subsequent to the October 2014 date?
No,
So when you say that you added additional vegetation for a neighbor, that was all incorporated, or the site engineer did, that was all incorporated in that October 2014?
yes, the plan that we discussed tonight changed in July 2014. After that was a lengthy discussion of stormwater, which began around Labor Day with a plan submission that was all about stormwater for months. You were probably here for all that.
Probably. Did you read those transcripts? I think I was here.
So anyway, this plan that you see here now changed finally at its final moment when tweaks were made for detention purposes. But other than that, the panels, the fencing, the buffering, all that was established by Mr. Kennedy just before you started that stormwater dialogue.
That I got a little confused on your testimony when you were asked in the beginning what transcripts you reviewed, and then you said I reviewed all the transcripts, but you didn't review the stormwater transcripts?
Correct?
You realize that there was a lot of cross-examination about stormwater before the July 2014 revisions and additional soil studies that were undertaken?
Yes.
So what did you read about stormwater?
So I did not read the transcripts on stormwater because we've been having preparation meetings for this hearing, and I discussed with Rob the entirety of his stormwater testimony, cross, plan adjustments. Remember, there was discussion about borings, and that was obviously easier to do with him sharing with me what happened.
So the area in the Long Meadow that is going to be retained as farmland,
Yes.
you know that there was a very large panel array proposed in that area.
I explained that earlier, yes.
Did you read the transcripts with the questioning as to the stormwater implications with respect to that area?
No.
So you're not aware of the fact that stormwater precluded or made it very, very difficult to use that area of the site?
I don't think that's in the record.
So,
The record will speak for itself, Mr. Hall.
Yeah, but you're characterizing the record, and I disagree.
All right, you know what I'll do? When I come back the next time, I'll just get the quote from the record. I
It's
think I'm
irrelevant
pretty good,
because
Mary.
it's not there now, so I think we're wasting time.
All right, I think it's a good time now to talk about when we're going to come back to continue the line of questioning and then have public comments. Paul, how does the calendar look?
We have two applications on for November 5th, so the next open would be November 12th.
Mr. Toby's not good there. We'll have to go to December. First meeting in December, is that third, I think?
Yeah, it's the 3rd. How does that look for you,
hold on a second.
Mr. Sasso and Mr. Nato?
November is no good for me here.
Yeah, no, we're saying
December
No, I'm
3rd.
saying December's fine.
Yeah, okay, that's what we're saying. November doesn't work.
The 3rd of December works?
Well, I've had a long-standing conflict, and I've rearranged my schedule numerous times for the 1st,
Right.
and I am retiring from that position. So that first first Thursday of December, it's kind of like one of the last, I'm going to be the first and the third, the last two meetings I'm going to be there, and I really don't want to send a substitute.
Are you available, Mr. Tobia, on the 10th?
No,
No.
I'm available on the 3rd.
All right, well, obviously, if Mr. Nada can't make it on that day, then we'll have to move it. You know, if you're not available on the 10th and she's not on the 3rd, then it looks like we would either have to go into January or propose a special meeting. So I would recommend going to January.
So, hold on a second. I just can't make.
Which would be the
I can't make December 10th. It's all-
7th or the 14th?
Are we asking now January, Mr. Chairman?
7?
Yes.
I'm available both of those days. Thank you.
Okay.
I have to check with my client.
Sure, sure.
What? I don't want any special meeting in December.
No way. Not one.
No, maybe not. Special meeting.
No, we're into January. I mean,
We're concerned about January. We know we can't do November, we're agreeing that. I mean, December, I mean, how many more questions does she have? Let's finish it tonight. I mean,
no, we're through for tonight, Mr. Hall.
yeah. If we could carry it to the 3rd, and we'll try to reschedule if you can give us another date, but he's not available on the 10th.
And she's not available.
I mean, the questioning could have been far more quicker than what occurred, I mean, frankly.
So
What's the rush, Mr. Hall? Is there a rush? I mean, you know.
We're skipping November, we're not arguing about November, but we're talking 2 months instead of 3 months.
Well, you know, if folks are not available, what do you want me to do? We
I don't
try
know,
to find a date that works for everybody, unless you want to propose a special meeting, and that's always very tough to get everybody, especially at holiday time.
It seems like she could have been more concise. I don't know how many more questions she has. I mean,
No, listen, you know, I think she was doing her job, and now we need to schedule a date, so let's figure it out. I think we're at January. You said you're good for both Thursdays, right?
Yes, I am, very.
All right, Mr. Hall, what about you and your client? I think it's the 7th or the 14th.
it sounds like you're not giving me a choice, so.
Well, are you the 7th or the 14th?
7th.
7th. Sounds good.
November, you can't come.
Is that the last witness, so we should bring our planners?
Well, we have lots, I'm sure we're going to have public questions. The board will have questions, I'm sure.
Okay.
I'd rather, I don't care. But, Mr. Hall, do you have any other witnesses after Mr. Tobia and before the objectors present their case?
Thank you, Mr. Collins. That's what I think Mr. Sasso was trying to find out.
Yeah, we haven't made that final judgment yet.
Okay. Could you let, if you are going to have another witness on
Before that
7th,
meeting, we will let
you
you
would
know.
let the board know and let the the two attorneys at least, by a letter that would be a public record.
Okay, we can do that.
Doesn't have to be anything more than the name and the address of the witness. And if they're going to have an expert report, maybe you could produce it.
Okay.
Okay, and so we're going to carry the KDC application without additional notices to the January 7th, 2016 meeting. That's the first time I had to say that publicly, I think. Kind of
I
impressive.
assume you'll be reorganizing that, make you expect any changes in the board? You know if there'll be any changes?
7 p.m.
Sorry. I don't know, Gary. It's kind of a lot of planning.
I just moved, you knew. Yours. Okay, thank you.
So 7 p.m., January 7th, 2016, this case is carried to without additional notices.
Okay,
Thank you very much.
good night.
Hold on. Okay, good. So your motion to adjourn.
You got the motion.
Okay, second.
I knew they were going to say.